As
中国国际经济贸易仲裁委员会是中国第一家
bankruptcy and reorganization law, etc. And Professor Shi is also a CTEC arbitrator. And thank you very much for our distinguished tribunal to participate and act as navigators, inspiring the participants to learn more and try more. The team for the final are team number 6, representing the claimant, and team number 19, representing the respondent. And the core issues to be addressed by the teams include issue 1, 2, and 8. Next, I'd like to draw the parties' attention to the following ground rules. The claimant and respondent each has 45 minutes in this hearing. Before the start of the hearing, the teams may negotiate on the sequence of presentation, time allocation, and rebuttal and surrebuttal arrangement, and inform the tribunal of the result. The tribunal has the discretion to make a final decision after hearing the team's opinions. Besides, the teams should be responsible for counting the time. If one team believes that the other team is about to exceed or has already exceeded the time limit, they may remind the tribunal in a proper manner. So that's all. Now let's focus on and enjoy the hearing. I will give the floor to our tribunal. Please.
Right. Well,
中国国际经济贸易仲裁委员会，1956年以来，当事人涉及100多个国家和地区，受案量位居世界前列。根植中国，服务全球。
中国国际经济贸易仲裁委员会是中国第一家仲裁机构。60多年来，贸仲不仅培养出了大批优秀的中国国际仲裁员，而且为中国仲裁立法的制定和完善及中国仲裁乃至世界仲裁事业的发展做出了重要贡献。
1956年。
Time of speech for issue 1. My co-counsel Fu Jiajun, he will be addressing this issue, and he will speak for 30 minutes and reserve 2 minutes for rebuttal. And for issue 2 and 8, my name is Chen Yiwen, and I will be addressing those 2 issues. And respectively, I will speak for 30 minutes and reserve 2 minutes for rebuttal.
right. Thank you.
For claimant, my co-counsel Ms. Chen Lunyu will address issue 1 and issue 2, and she will use 13 minutes for submission and reserve 2 minutes for rebuttal. My name is Yu Yingke, and I will plead for issue 8. I would use 13 minutes for submission and reserve 2 minutes for rebuttal.
Right. Thank you. So the respondent will begin.
Members of the tribunal, my name is Fu Jiajun. I appear on behalf of the respondent, CDO Priani, to address issue 1. In keeping purpose with the ICSID Convention, the respondent submits that the double barrel test should apply. Thus, the claimant has failed to establish jurisdiction for either one of the following 2 reasons. First, it is not investment under Article 25 of ICSID Convention. Second, it is not investment under the current BIT. To begin with, the respondent contends that the salinity test should be applied in the present dispute. Members of the tribunal, the salinity test is like a house of cards. If one element fails to hold, the entire credibility of the salinity test crashing down, especially the risk element. In Post-Avoca versus Greece, the tribunal holds the opinion that the investment risk is different from commercial risk and sovereign risk. And then the tribunal explains that The commercial risk includes the risk of one of the parties might default on its obligation, and the sovereign risk includes the risk of interference with the government. In the present dispute, as for the commercial risk, it is the censor who did not enable the Pubblicani to use the soft pens, then it is default on its obligation under the contract. Thus, it is a commercial risk. As for the sovereign risk, in the present dispute, the Roman Senate made the final decision which are in favor of the city of Priene with the two preliminary injunctions. So it is our submission that it is an interference with the Roman government that caused the claimant or the Pubblicani harm. Thus, it is not an investment risk, but a commercial or sovereign risk. In sum, the claimant has already failed the Zanini test, thus the tribunal does not have...
Well, Councillor, I have a question. Councillor, I have a question. You said the sovereign risk materialized. Isn't that the purpose of an investment treaty, to protect against sovereign risk? Is that something you should be looking at for the definition of investment?
Yes, it is. The aim and the purpose is to protect the investments under the BIT to prevent the interference with the government. However, in the present dispute, it is the Roman Senate that has, with two preliminary injunctions about the ownership of the soft pens, that in favor of Priene, that have caused the claimant and Pubblicani harm. That's
Counsel, if you don't mind, I interrupt you. You mentioned the failure of salinity test. Could you please clarify a little bit why?
Thank you, Madam Arbitrator. To address your concern that the respondent contends that the Zanini test should be applied in the present dispute, because despite all those controversies about the Zanini test, it is the fourth element, that contribution to the host economic development, that has been criticized a lot. However, in the present dispute, the respondent acknowledged that controversy and decided to reuse the original three elements of the Zanini test, which is the duration, risk, and contribution. And second, those three elements derive from the original meaning of investment, because according to Black Law Dictionary, an investment is a transaction which party invests money and expectation of profits derived from the efforts of the third party. And this has also been confirmed by the tribunal in Sabafax versus Republic of Turkey. And third, regarding the practice of Zanini test, there are many ICSI tribunals and non-ICSI tribunals who are all using the Zanini test to define whether it is an investment. If I address your concern, that I'm proceeding with our next submission.
Yes, please do. Yeah.
Now move to our attorney argument. The respondent here contends that we should not apply a literal approach to interpret the investment definition under Article 1, Paragraph 5 of the BIT. Members of the tribunal, the fact that it falls within one of the categories listed in Article 10 does not transform it into an investment, because literal approach cannot be the way to interpret Article 1, Paragraph 5. First, literal approach to interpret Article 1 would effectively ignore the second sentence of Article 31 of the Vienna Convention, which requires the interpreter to take into account the ordinary meaning and their context and objects of the purpose of the BIT. And for the convenience of the tribunal, the respondent quotes that such investments will be conducive to stimulation of individual business initiative and will increase prosperities in both areas. This suggests the intent to protect kind of assets, distinguish them from merely ordinary commercial transactions. In addition, a mechanical application to interpret Article 1 of the BIT would also be absurd and unreasonable. Take Article 1, Paragraph 5. Let us see, for for example, the literal approach to interpret that article would mean that every contract between a national of Pergamon and the Roman Republic would constitute an investment under the current BIT, regardless of the nature of the contract. And this would in turn mean that the Kingdom of Pergamon and the Roman Republic would have renounced their application of domestic law and surrender the jurisdiction.
中国国际经济贸易仲裁委员会，1956年以来，当事人涉及100多个国家和地区，受案量位居世界前列。根植中国，服务全球。
中国国际经济贸易仲裁委员会是中国第一家仲裁机构。60多年来，贸仲不仅培养出了大批优秀的中国国际仲裁员，而且为中国仲裁立法的制定和完善及中国仲裁乃至世界仲裁事业的发展做出了重要贡献。
1956年，对外贸易仲裁委员会由中央人民政府政务院批准成立。中国仲裁事业由此开端。1986年，贸仲以国际化的事业推动中国加入纽约公约，使中国的仲裁裁决可以在纽约公约现今150多个成员国得到承认和执行。1994年，中华人民共和国仲裁法颁布，贸仲长期的仲裁实践和先进的仲裁规则为。
The categories are not exhaustive. However, it indicates that there may well exist categories different from those mentioned in the list. Accordingly, there must be a benchmark against which to assess those long-listed assets to meet the definition of investment under the current BIT. And third, to address business concession conferred by law and under contract. It may fear first appearance that this contract falls into the definition of D. However, the respondent contends that the current contract in the dispute is a sales contract, and the BIT did not include a sales contract. For the sales contract, the respondent has 2 points to make. First, from the formality of the contract, members of the tribunal may direct you to paragraph 15.2.
52 of what?
Of the case
right.
files.
Yeah.
The last sentence, the tender auctions were held, it indicates that if the auctions were held under the spear, it was just as the auctions and sales of spoils of war. That means that if the auctions, from the formality of the contract, if the auctions held under the spear, it would indicate the sales contract. And paragraph 14.2 of the case file, line 3, it says that it was this auction.
Counsel, my recollection. Counsel, my recollection is that also when the Roman Republic contracts for services, such as the building of temples, it also uses the same process of the auction under the spear. So how does that support your argument?
Yes, Madam Arbitrator, this is one of the arguments that about the formality of a contract, and also from the substance of a contract, it is also a sales contract because the respondent contends that the Roman law is decisive in determining the nature of the contract. And according to SPP versus Egypt, Vasily Group versus Venezuela, the governing law of the contract is the domestic law. Because reference to national law is very necessary to verify the ownership, the content, and the recognition by the state. And in our case, the contract uses standard terms. On the paragraph 15.8, it used the word Lakari Vanderwerf. And according to the footnote of 17.1, it also stated that in the Roman law, when sales contract includes the object of sale of utilization of public property. And this contract is the sale of utilization of public property because Article 57 is stated that the object of contract, it states that extends to the publicanis to use them as a kin deed. Thus, the respondent contends that it is a sales contract under the Roman law and it should be excluded from the current BIT.
Counsel, may I have your further clarification? So you probably, if the claimant can gain benefit from that contract, how does that fit into your argument? So this is not an investment according to the BIT Article 1 definition.
Madam Arbitrator, to address your concern that, as the respondent already mentioned before, the logic of Article 1.5 indicates that there is an inherent meaning against the definition of assets. That does not necessarily mean that every kind of asset is an investment under the current BIT. And the
it clearly said it means every kind of asset. And you also agree it's not an exhaustive list.
Yes.
So I don't quite get your argument on this point.
Because when we're using the literal approach to interpret Article 1, Paragraph 5, would deprive the term investment of any inherent meaning. Indeed, the categories of the investment of BIT are not exhaustive. So there may well exist categories different from those mentioned in the list. And accordingly, there must be a benchmark to assess those long-listed assets to determine whether they meet the definition of investment. And like the tribunal in Romac versus Uzbekistan and GEA versus Ukraine, they contend that those...
What's the benchmark you just mentioned? What's the benchmark?
First, in the Romac versus Uzbekistan, which is a non-ICSID tribunal, there is no application of the ICSID convention, and the tribunal holds the opinion that the benchmark refers to that the BIT must exclude the sales contract, the ordinary commercial transaction, and also the investment. And the tribunal also refers to the salinity test, says that the benchmark also have to meet the three original elements of the salinity test, which is risk, duration, and contribution.
Can I just raise a question for claimant's counsel? You mentioned three specific scope. The domestic law, you were developing your arguments on domestic law. You started your argument with the international law referring to the Salini test, but rightly observed there are controversies as to its application, and then also the BIT. Now, in this three scope or three areas of law, how do you say we as the tribunal should approach in looking at the definition or whether the particular dispute fall within the definition of investment? Can you tell us how we should approach it?
Because under the Madam Arbitrator, to address your concern, under Article 42 of the ICSID Convention, the tribunal is stated that the tribunal shall apply the law of the contracting party to the dispute or international law if there is in the absence of the agreement. And as for the ICSID, because it's an inherent meaning under behind the term investment, and the BIT is also within the scope of the ICSID. That's why, that's how we should interpret the definition of investment.
If I could ask a question of you, counsel, just somewhat different. The claimant, if I'm correct, is Titus Pomponius. the son, the successor to the older Titus Pomponius. Is that right?
Yes.
And we know that Titus Pomponius, neither the father nor the son, was a publicanus. In other words, the lease was not made out to either Titus Pomponius or to his son. Is that right?
Yes, it is. According to the case file, it is not clear whether the Titus is a membership of the publicanus.
But we know that he wasn't the publicanus, and we know that the salt mines were leased to the publicanus, and so the salt mines could not have been leased to the claimant. Am I correct so far?
Yes, Mr. Arbitrator.
What Titus Pomponius did, or what his son did, is they lent money to the publicanus. And that, as I understand it, was a non-recourse loan. In other words, the monies that were loaned were to be repaid out of the proceeds, the profits obtained from the salt mines. Am I correct on that?
Yes.
Now, given that this is some sort of indirect investment, it's not an actual lease of the salt mines that we're concerned. The claimant is concerned with getting his monies back from a loan made to the publicanus. How does that, if at all, affect your analysis either of ICSID 25, Article 25.1 or Article 1.5 of the BIT?
To address your concern, Mr. Arbitrator, first, the respondent contends that the issue 1 is focused on the contract, whether the alleged contract is an investment, not the long-recourse loan, whether it's an investment.
So the contract, you say that the contract that we're concerned about, notwithstanding that the claimant is Titus Pomponius, is the lease of the salt mine. Is that right? That's what you say. That's the case.
Is the alleged contract is the awarded by during the auction from the censors? That's the alleged.
The censors awarded to the publicanus. They didn't award it to Titus Pomponius.
Yes.
So, but you say that the contract or so-called investment that we're focusing in on here is the lease of the salt mines, the contract of the salt mines, not the loan. Is that right?
Yes, we should focus on the sale of the sale contract, not the non-recourse loan on issue 1.
Right. So the answer to my question is the fact that Titus Pomponius, the claimant or his son, are seeking effectively a return on their loan to the publicanus doesn't affect your analysis at all. Am I right in that?
Because the long-recourse loan, even if it is on the definition of the ICSID or the BIT, it is a loan it is a Titus, a national of Rome, lent to the national partnership Publicani. So that does not constitute an investment in the bilateral investment treaties.
I'm afraid I don't quite understand your point, counsel. I think what you're trying to say, but you can correct me if I'm wrong, is effectively this is a loan between one Roman citizen, Titus Pomponius, to a Roman publicanus. So this has nothing to do with an international loan. This is purely a loan from one Roman to another Roman, and therefore it's not an international matter, and none of the BIT or the ICSID really touches upon this, and this tribunal has no jurisdiction. Is that your argument?
Yes, this is my argument.
Right, thank you.
And to conclude, the respondent contends that the claimant has failed to establish jurisdiction for either one of the reasons we discussed above. First, it's not an investment under the Article 25 of the ICSID Convention. Second, it is not an investment under the current BIT. And that concludes my submission. Thank you.
Thank you very much. Ms. Chen?
Members of the tribunal, Mr. President, I am Chen Liwing. I will represent claimant in this proceeding dealing with issue 1. And regarding issue 1, claimant insists that the business concession contract, along with a non-recourse loan, constitute an investment jointly, and the tribunal has jurisdiction over the current dispute. Claimant mainly has 3 submissions. First, claimant would like to recommend the tribunal to apply a subjective test in identifying a qualified investment rather than applying the double-barrel test offered by the respondent. And second, applying the subjective test, the overall transaction falls within the definition of Article 1, Section 5 of the Bilateral Investment Treaty. And third, even if applying the double-barrel test offered by the respondent, the transaction qualifies an investment under the Article 25, Section 1 of the ICSID Convention. And moving to our first submission, claimant recommends the tribunal to apply the subjective test in identifying the existence of investment in the present case and refutes the double-barrel test offered by the respondent. This is because the ICSID Convention does not provide a specific definition of the word investment. It is correspondent with the intent of the Convention's drafters to leave the parties' discretion to define what investment is. It is thereby, claimant thereby recommends the tribunal to assess the term under the Article 1, Section 5 of the Bilateral Investment Treaty, and the objective requirement offered by respondent cannot go beyond the parties' genuine will within the Bilateral Investment Treaty. And moving to our second submission, claimant submits that the investment falls within the definition of investment under Article 1, Section 5, Section D of the Bilateral Investment Treaty. If I could refer the tribunal's attention to Article 1, Section 5, Section D of the Bilateral Investment Treaty.
I think the tribunal understands the point that you're making, counsel, and our attention has already been drawn to Section 1(5). My question to you is this. You insist that the investment is the non-recourse loan plus the salt mine concession. But why is that? Now, you've heard counsel for the respondent, in answer to my question a moment ago, said if you step back and look at it, effectively what you have is a loan from one Roman citizen to a Roman publicanus. There's no international element at all. Why do you tie in the salt mine concession? Isn't really the investment what your client is making a claim about is it hasn't got back its money on the loan. So this is really just a domestic matter, not an international matter. What do you say to that, counsel?
Well, we recommend the tribunal to consider the non-recourse loan as well as a business concession contract, which is a contract of the salt pans jointly, because the investment...
Why, counsel?
Yeah, because investment in the present case is very complex and cannot be separated and consider each of them separately. And also in relation to your concern about this is a domestic dispute, it's claimant's submission that the non-recourse loan, even if it's between the publicani and claimant, it is finally used as a capital to the operation of the salt pans. Thus, the respondent state, which is the city of Priene, and also the province of Asia, has benefited from the money that we lend to the publicani. Thus, we argue that the tribunal should consider the non-recourse loan as well as the concession agreement together, since they cannot be separated in the present case.
Right. If I could just follow up with 2 questions then. One is this. Does it make a difference that the loan is a non-recourse loan? In other words, the loan is to be paid out of the profits, if any, from the salt mine. The second question is my concern is the monies were loaned from the Roman citizen, Titus Pomponius, to the publicanus. That's basically a loan from one Roman citizen to another. How is there an investment, something brought in to the other country, into Priene? Nothing seems to be brought in. The loan was simply being made to a Roman corporation in Rome. Nothing involves a foreign element, nothing in Pergamon. So how can this be an investment in Pergamon? Those are my 2 concerns.
Thanks for your question, Ms. Arbitrator. In response to your first question about the difference between, about whether there would be a difference between the honorary cost loan and the loan itself regarding the definition of investment, it's claimant submission, whether it's an honorary cost loan or it is a loan, it's lent by a claimant to the public company as a capital that used in the operation of the salt pans. So whether it's an honorary cost loan on the loan would not make a difference regarding this type of investment. And regarding your second question, which is how does a loan finally flow into that country, it's our submission that in the present case, the case study does not offer evidence regarding this. However, it could be presumed that if our claimant has lent an honorary cost loan to the public company, which is a corporation, the most important work of the public company, the corporation, is to operate the salt pans. They would definitely make use of the loan that lent by our claimant into the operation of the salt pans. Thus, it will constitute a loan itself.
Thank you.
Counsel, can I just ask you this question? Much has been said about the loan part of it. Do you say it is relevant for us to consider the loan part of this?
I'm sorry, Mr. Arbitrator, could you...
Professor Reyes has talked about the loan aspect of it. Do you say it is relevant for our consideration on issue 1 to consider any aspect of the loan? Because I'm not quite clear as to what your case is regarding the loan and this issue which we're considering.
Thanks for your question, President Arbitrator. We recommend the tribunal to consider the loan because the concession agreement is in fact between the public company and between the city of and the Vermont Sensors, which has a direct relationship with our claimant if the tribunal were only to consider the contract itself. And the loan is actually how our claimant have an access with the whole investment, and that's why we recommend the tribunal to consider the loan and the contract together.
I see. So we're considering 2 contracts, are we?
Yes, that's right.
All right.
So if there answers the tribunal's question, I would move on to my submission. And as claimant argues that the loan and the contract, they would together fall under Article 1, Section 5, Section D of the Bilateral Investment Treaty, which is a business concession agreement, and our loan is used as a capital to such kind of concession agreement that is used to operate the salt pans, which cannot be separated from such concession agreement and is regarded as an integral part of the agreement. And moving to our third submission, even if the tribunal would like to adopt a double barrel test and consider the outer limits set in Article 25, Section 1 of the ICSID Convention, is claimant's submission that our transaction has qualifies all the requirements under Article 25, Section 1 of the ICSID Convention. And respondent first argues that this is a contract, simply a sales of goods contract, thus is a purely commercial transaction that ought to be excluded from the tribunal's jurisdiction. And claimant has 2 responses to this argument. First, we argue the contract is in fact a leasing contract, but not a sales of goods contract.
Sorry, I can't.
I believe counsel was muted. Someone muted claimant.
Ah. Can't hear the claimant, like Dr. Conrad, I can't quite hear. Can't hear anything.
Yeah, CTEC, we're seeing the mute button sign for the camera that gives us claimant's feed, and it instead respondent's microphone is open. Can you please switch to claimant so we can hear claimant? CTEC operator co-host, could you please unmute claimant? It's not something that the students can do. It's something in the video conference. They're muted. We can't hear them.
If the tribunal could hear me? My apologies. If the tribunal could hear me, am I audible at the present?
Could I kindly ask the tribunal secretary to communicate to the technical team or, the host to unmute the claimant for video conference? The camera seems to be muted.
Can I echo that? The only person I can hear at the moment is Dr. Conrad.
I can't speak Chinese. Maybe the co-host speaks better Chinese than English. So if one of the Chinese speakers could.
OK, Alice。那个秘书在吗？赵爽在吗？
Sorry, if the tribunal could hear me at present.
I think we've lost our secretary too.
It seems that we have.
Can't see the respondent.
Can you hear
Claimant，
us?
你能在现场看一下是怎么回事？你们在现场赶快告诉我们，他听不到。
I'm sorry, am I audible at present?
I can just hear the claimant just now, so try again, claimant.
No, I think that's not claimant. I think that's respondent who we're hearing.
Yeah,
I
from
see.
respondent instead of claimant.
Members of the
那
tribunal.
被 respondent， 那你们能告诉
Maybe we can pass the microphone to the claimant for the moment for there to can be heard.
Thank you very much. Great idea, and thank you for your cooperation.
Members of the tribunal, am I audible at present?
Yes, we can hear you now.
Yes, can hear you now.
So I'll move back to my submission. I'm sorry for the technical problems. I'm moving.
I think we lost you when you were dealing. I lost you anyway when you were dealing with your third point.
Yeah, thank you, President Arbitrator. So I will resume at the place when you lost me. So moving to our third submission, a claimant argues that even when applying a double barrel test offered by respondent, our investment has qualified the definition under Article 25, Section 1 of the ICSID Convention. And respondent argues that first, they argue that such contract is a simply sales of good contract, thus it is a purely commercial transaction that ought to be excluded from the tribunal's jurisdiction. And claimant mainly has two responses to this argument. First, we argue that this contract is a leasing contract rather than a sales of goods contract, and there lacks evidence regarding the direct transfer of the ownership in the present case. And the form of auction, as respondent has submitted, would not alter the nature of the contract, since the leasing contract should also be awarded at the auction. And as supported by Gaius, that the understanding as locatio conductio, which is leasing contract, would be preferable, whose view is supported by numerous authorities and numerous sources. And even if the tribunal were to determine that the contract is a sales of goods contract rather than a leasing contract, it would not necessarily lead to the conclusion that our transaction is not an investment. Such an approach is supported by case law, which is the Petrobot Limited versus Kringens Republic.
Sorry, I've just lost sound.
We cannot hear you again. 你能再试一下吗？ 是麦克风的问题还是
Members of the tribunal, am I audible at present?
No, still cannot.
No, cannot hear it. Can anybody else hear anything? Can
Member of the
Anselmo,
tribunal,
Teresa?
can you hear from the respondent?
I'm in the same position as you are.
Yeah.
Something must
Member
have
of the
been pressed
tribunal?
accidentally.
I think I suggest the respondents again try to give their microphone because I think they were going to try and use.
But
Members
this
of
does
the
not seem
tribunal?
this does not seem satisfactory.
It seems the equipment of the respondent
Let
cannot
me
be
leave the
used
room
as
and
well.
see if someone of the technical assistance team is in the main.
I think we
You
need
may
to-
not be able to get you may not be able to get me back. If I can't get back in, just proceed without me. But I'm trying to find someone, so let me try this.
Thank you.
Can the claimant try and speak into that microphone and let's see if it's working at the moment?
Members of the tribunal, can you hear from the claimant?
We can now, but let's wait a little bit. We'll see what.
So if the tribunal could hear me, even if the tribunal were to determine that the contract is a sales of good contract, it does not necessarily lead to the conclusion that this contract is a purely commercial contract. A loan devoted to such contract could still constitute an investment. Such an approach is supported by the case Petrobras Limited versus Kyrgyz Republic, where the tribunal contends that the claims to money, even if not based on a long-term involvement in a business in another country, are included in the concepts of an investment. And in the present case, the loan offered by claimant is devoted to the operation of the SOCPANs, which was to be repaid from the proceeds. And whether or not this contract is a sales of good contract, whether or not the ownership has been transferred to the public company or not, it would not change the fact that the non-recourse loan is devoted to the operation of the SOCPANs, which constitute a typical investment. And respondent also submits that our transaction has failed to meet the requirements under the Cellini test, and they have pointed out that under Cellini test, 4 requirements ought to be met, namely contribution, duration, risk, and contribution to the development of the whole state. And respondent mainly challenging the 3rd criterion, which is the risk criterion, and his claimant's submission that we have already satisfied such criterion. We have to remind the tribunal there's no generally applicable standard regarding the risk requirement. Since in some of the case, the tribunal would argue that all of the risks happened would satisfy the risk requirement and did not have to be an investment risk. And in the present case, claimant argues that the existence of investment dispute before the arbitral tribunal would satisfy the requirement of an investment risk, of a risk requirement, which is supported by the case Deutsche Bank versus Sri Lanka. As in that case, the tribunal ascertains that if there would be a dispute, an investment dispute before the ICSID tribunal, then the risk requirement is satisfied. And since respondent submits that our risk has to be an investment risk, we have to remind the tribunal that this criterion and this standard is not generally accepted by all of the international tribunals. And even if the tribunal would like to hold that the risk assumed by claimant must be an investment risk, and its claimant submission that we have already satisfied such kind of requirement, because as argued by the Seo Jing Han versus Republic of Korean Tribunal, the risks inherent in the commercial transactions are called the commercial risk, and any risks which go beyond such risks which could be identified in a commercial transaction would qualify an investment risk. And in the present case, my client has suffered the risk of expropriation of the SOCPANs within the territory of the PRIEN. Thus, we argue such risk would not appear in any commercial transactions and would only exist in the investment transactions. Thus, we argue that claimant has already satisfied such kind of risk.
So Council, sorry to interrupt. I'm wondering, do you have any more clear criteria to distinguish between commercial risk and investment risk, or any criteria you tribunal to consider on this issue?
Thanks for your question, Madam Arbitrator. We recommend the tribunal to adopt the standard listed in CO Jin Han versus Republic of Korea, as in that case, the tribunal held that the investment risks are different from the commercial risks, and the risks inherent in the commercial transaction are called commercial risks, and any risk which could go beyond the risks that exist in the commercial transactions would constitute an investment risk.
So is this about the control from the investor, or is there any other factors to consider?
Well, in that case, the tribunal also specifies that, for example, the risk of expropriation is a typical form of investment risk, which is out of the control of the claimant, but this is not the standard we would like to apply. We would like to apply that any risk that could go beyond the commercial transaction would constitute an investment risk.
Please proceed.
Thank you. So in conclusion, as a claimant submits that first, we recommend the tribunal to apply a subjective test, but not a double-barrel test, since the objective requirement should not contradict the genuine will of the contracting parties. And second, even if the tribunal would like to apply a double-barrel test, claimant has satisfied, since a contract is not a sales of goods contract, but a leasing contract, which is a typical form of investment, and we have also satisfied the requirements under the Salini test. And that concludes my submission. Thank you.
Perhaps I could just ask one question, Counsel. You've stressed the need for a subjective test. Whose subjective intentions should we take into account? Titus Pomponius, the Publicani, the citizens of Praini? Whose subjective intentions do you say we should take into account in assessing whether the so-called investment by our client is an investment within the terms of the ICSID Convention and the BIT?
Thanks for your question, Mr. Tribunal. It's claimant's submission that the intention that should be taken into account is in fact the contracting parties, which is the state's intention when signing the bilateral investment treaty, because they signed such bilateral investment treaty in order to promote the investment in both of their areas. Thus, it's our submission that when identifying the existence of a qualified investment, we should follow the intention of both of the contracting parties' intention. Thank you.
Right, and where would we infer these subjective intentions from?
We could infer the subjective intentions from the wording and articles of the bilateral investment treaty, as it is very clearly reflected in Article 1, Section 5 of the BIT, which is an open-ended and non-exhaustive list of the definition of investment.
Thank you.
So your submissions are concluded?
Yes, Mr. President.
Right, thank you, thank you. Now, we now need a response from the respondent.
Yes, members of the tribunal, can you hear me?
Yes, thank you.
Regarding the rebuttal, the respondent has 3 points to make. First, the claimant's position is self-defeating and inconsistent regarding the long recourse loan. At first, he says that the Publicani used the loan as a capital to the SoftPans. Later, the claimant then contends that there is no evidence to show that, and it is presumed by the claimant. Second, regarding the nature of the contract, the respondent contends that we should not rely on a scholar interpretation of the contract, and Roman law is decisive in determining the nature of the contract. And third, regarding the subjective test, we should look at the intention between the publicani and the Roman census under Roman law, which is a sales contract and is not investment, whether under BIT or the investment Article 25 of the ICSID Convention. And that concludes my rebuttal. Thank you.
Right, thank you. Thank you, Mr. Fu.
So in response to a respondent rebuttal, claimant has 3 points. First, regarding the forms of investment, we argue that the contract and the loan consistently and together constitute investment, as the loan is used as a capital to that kind of operation of SOCPANs. And secondly, if the tribunal were not buying, would not like to buy this argument, we argue that the concession agreement itself will constitute investment, as it falls under Article 1, Section 5, Section D of the Bilateral Investment Treaty. And second, respond to the nature of the contract, respondent submits that we cannot rely on a scholar's interpretation. However, the scholar's interpretation is offered by the case study regarding the interpretation of the Roman law, which means that even under the Roman law, the nature of the contract is a leasing contract rather than a sales of goods contract. And that concludes my rebuttal. Thank you.
Right, thank you. Now we move on to the next issues. Issues 2 and 8.
Mr. President, can you hear from the respondent clearly?
Can do. I can hear you clearly. Thank you.
Thank you. Good day, Mr. President, members of the tribunal. On behalf of the respondent, I will be addressing issue 2. Members of the tribunal, the claimant is asking for something that it never had. After having failed 3 times in the judicial proceedings in Rome and failed to obtain the rights over the salt pans, the claimant keeps disrupting the proprietorship of the respondent by manipulating investment arbitration. And regarding issue 2, the respondent submits.
I'm sorry, counsel. I'm sorry, counsel. You just say they're interrupting the property rights of Priene. My understanding is that Titus Pomponius only extended a loan. He was not involved in the attacks in your submission on the temple's salt works.
Madam Arbitrator, if I understand your question correctly, as the counsel for the claimant has just stated, that the concession agreement and the loan should be looked at and considered together. And if you would allow me to enter into my main submissions. So regarding issue 2, the respondent submits that this tribunal does not have jurisdiction ratione materiae for 3 reasons. So number 1, whether the salt pans fall under the scope of contract is an issue for jurisdiction and not merits. Number 2, the Roman Senate has decided that the salt pans will not be included in the scope of contract, and that decision has res judicata effect on the claimant. And number 3, even if the decision does not constitute res judicata, the decision should at least be considered as a matter of fact against the claimant for this tribunal. And moving on into our first submission, the issue over the scope of contract is purely jurisdictional. The existence of a contract or that the salt pan falls within the scope of contract is decisive in determining whether the claimant actually has an investment or not. To satisfy the jurisdiction ratione materiae, the claimant must prove definitively that it has an investment. This can find support in the case SGS versus Paraguay, in which the tribunal opined that, quote, for issues that are directly determinative of the tribunal's jurisdiction, such as covered investment, if the tribunal is to make jurisdictional determinations, it must first reach definitive findings of fact. And in the present dispute, if I may refer members of the tribunal to page 13, paragraph 57 of the casebook. Page 13, paragraph 57.
Yes, we've got that.
Thank you. Thank you for your feedback, Mr. President. So this is a paragraph that recorded the salt pen agreement based on which the claimant alleges the existence of an investment. And without this contract, the claimant has no other basis to claim its rights over the salt pens or in the agreement. And as will be shown by the respondent in our next submission, the salt pens in question never fell under such contract. Moving into our next submission, the Roman Senate has decided that the scope of contract does not include the salt pens in question, and this decision constitutes res judicata for the claimant. If I may refer members of the tribunal to page 1, paragraph 3 of the casebook. Page 1, paragraph 3, from line
Yes.
4. I will quote for the convenience of the tribunal that for the purposes of the moot, we will adopt the view that the dispute between the Roman Publicani and the city of Priani was about whether the salt pens in Priani were covered by the concession agreement, end quote. And regarding this dispute, if I again may refer members of the tribunal to page 20, paragraph 88 of the casebook. Page 20, paragraph 88. It is stated that the claimant is not very happy when he learns of the decision of the Senate in favor of the Priani. And this means the Roman Senate has rendered a decision that such salt pens would not fall under the scope of the contract. And regarding why this decision has res judicata effect, the respondent will raise two submissions. So number one, this is a judicial decision, which can be seen from the casebook that both parties, both the Publicani and the city of Priani, have pleaded in front of the praetor and the proconsul of Asia. And for that reason, to define res judicata, it is generally, in accordance with the 2004 interim report, res judicata refers to the general doctrine that an earlier and final adjudication by a court or arbitration tribunal is conclusive in subsequent proceedings. And for res judicata to apply, the respondent is aware that the claimant might raise the triple identity test to be satisfied, namely that the parties must be the same in the two proceedings, the subject matter must be the same, and the legal grounds must be the same. And the respondent's case have satisfied those three conditions.
Just interrupting you, why do you say the Senate proceedings are a judicial proceeding? I'm trying to look at the case study to see which paragraph says that. I mean, the Senate doesn't appear to usually to be a body that is a judicial body.
Thank you for your question, Mr. President. May I refer you to page, this has been proven by several times in the casebook. If I may refer you first to paragraph 65 on page 14 of the casebook. Page 14.
Yes.
Paragraph 65. It can be seen that both parties, it is said that the city of Priani chose Crace to plead the case. It can be seen that both parties have pleaded their cases in front of the praetor, who is the local judge at the time. And it can also be seen in paragraph 68 of the casebook. Page 15, paragraph 68. It is said that the praetor, the local judge, issued a temporary injunction in favor of the city of Priani, ordering that the salt pans should remain in Priani's possession until the dispute would ultimately be decided by the Senate. And therefore, it can be inferred that the Senate is similar to a supreme appellate body, in accordance with whom the praetor must make a decision on. And given that such decision has been made, this decision can be considered as a judicial one. if there is no further question from the tribunal, I will move on to the satisfaction of the triple
Yes,
identity
please do.
test. Okay, thank you.
I think we understand the three tests, counsel. Perhaps you might focus in particular on the first test that you referred to, the same parties, because it would seem not to be the same parties. The claimant here is the lender, not the publicani. It is true the lender lent to the publicani on a non-recourse basis, but the lender, Titus Pomponius, did not take part in the arguments before the praetor. The publicani may have, and obviously the city of Priene might have, but not Titus Pomponius. So the parties would seem to be different. The other thing that you might clarify for me is, are you talking about positive res judicata or simply negative res judicata? In other words, negative res judicata, what is binding is simply the disposition, the dispositive of the senatus consultum. And then I would ask you in that case, what is the dispositive? If it is positive res judicata, such that issues, whatever findings of fact are made by the senatus, by the Senate, are binding, could you identify, please, what precise facts are binding on the claimant, Titus Pomponius?
To address your concern, Mr. Arbitrator, for your first question on the concern of the parties might be different, the respondent will raise 2 points. So, first of all, the identity of the party should be considered as the identity of the interest of those two parties. And as the counsel for the claimant has just admitted under issue 1, I quote, that the investment is complex and cannot be considered separately from the concession agreement. And this has been repeated for 4 times, saying the concession agreement and the loan cannot be considered separate, and that they both benefit from the capital invested and from the proceeds of the salt pans. And from this argument that has been proposed by the claimant, it can be seen that the claimant and the publicani's interests are highly connected and even overlapping. And in the case of Ample versus Egypt, even the 24% shareholders' rights can be covered within the company. Then in this case, it is even more convincing for the tribunal that the interests here are the same. And this is also why the respondent under issue 1 did not raise an objection against the claimant's status as an investor and only concerns the question of investment. And regarding your second question, Mr. Arbitrator, you're asking whether the respondent wants positive or negative res judicata. It is the respondent's submission that the respondent is raising positive res judicata, which means, in accordance with the IOA report on res judicata in arbitration, that the same issue of facts or the law, I quote, which have actually been arbitrated and determined by it, provide that any determination was essential or fundamental to the dispositive part of the arbitral award shall bind the parties in the latter proceeding. And in the decision rendered by the Roman Senate, it was decided, as I mentioned, that the salt pans did not fall under the scope of the contract. And that fact, and that is the dispositive of the decision, and the issue of fact that was addressed is also the scope of the contract. And for that reason, the respondent submits that the claimant is bound by that decision and should be precluded from a second bite of the cherry, from seeking another relief in this proceeding. And if that addresses your concern, Mr. Arbitrator,
Thank you very much. Thank you.
Thank you. And for the other two elements, so the second one is the identity of the cause of action. It is true that the claimant may raise that in the former proceeding made by the decision made by the Roman Senate, it was a contractual claim versus in the present proceeding, it was about the treaty violation claims. However, the respondent submits that we must look at the particular issue here. For the issue of the scope of contract, it only concerns the domestic law and does not concern with any of the treaty obligations. And under issue 1, it was only discussing whether such property rights would potentially constitute an investment. And so for that reason, the causes of action regarding this particular issue is the same in both proceedings. And regarding the last element, the identity of facts, it should not be disputed that the facts never changed. It was based on the premise of the claimant to ask for damages is the existence of an investment. And the existence of an investment is premised on the existence of a contractual right. And for that reason, the respondent submits that res judicata should apply to the claimant, and the claimant cannot sue again. And moving on to the respondent's last submission, even if this tribunal does not believe that the decision made by the Roman Senate should preclude the claimant from suing again, it should at least be taken as a matter of fact whether there is an investment. That decision, as I have mentioned, only concerns domestic law, and for which reason it should be considered as a matter of fact. This can be supported by the case Nincombe versus Latvia, in which the tribunal considered, quote, "The situation thus documented are facts interpreted by the Latvian courts concerning the Latvian legal situation that can be taken into regard by this tribunal without the need for the tribunal to re-embark on any interpretation or application of Latvian national law on its own." And therefore, the decision rendered by the Roman Senate should at least be considered as a matter of fact against the claimant's claims. To sum up, the respondent submits that this tribunal does not have jurisdiction rationale in materia because the claimant cannot establish definitively that there is an investment, and the Roman Senate decision should have res judicata effect on this claimant on the present dispute. Thank you.
Right, thank you. Claimant?
Members of the tribunal, Mr. President, regarding issue 2, claimant mainly had 3 submissions. First, we argue that the decision of the Senate has no res judicata effect. And second, even if the tribunal were to determine that it has res judicata effect, claimant could sue respondent for the sought pens made outside Priene, which is located in the province of Asia. And third, whether the sought pens belong to the scope of a contract is a merit issue which should not be opened in the jurisdictional phase. So moving to our first submission, we argue that the Senate decision has no res judicata effect. And regarding this, claimant mainly has 2 arguments. First, the decision is a political advice rather than a judicial decision. The Senate consultum is neither binding nor a judicial decision. First, the Senate consultum is simply a piece of advice whose effects are merely of consultative nature rather than a binding decision. As evidenced by its wording, it is simply a consultum, which means that it is simply a piece of advice. And second, the Senate decision is a political decision rather than a judicial decision. As evidenced by the history, the force of the Senate decision was due to the political influence of its members and to a question of social stability rather than legal. Also, since the Roman Senate is not a formal judicial branch, which does not have a power to make a legal decision, thus the Senate consultum is a simply political advice rather than a binding judicial decision, which would not have any res judicata effect before the exit tribunal. And second, claimant submits that the domestic decision does not have any binding force before an international tribunal. It is according to...
Could I just interrupt there, counsel? you accept that there were 2 temporary injunctions granted as a result of the decisions of the Senate, the Senatus Consultum. Is that right?
Yes, claimant submits that claimant submits there are 2 injunctions granted.
Right. And those injunctions, would you accept, had legal effect? They were not just political matters.
Yes, it's claimant submission. They are only political advice, since to distinguish between.
Sorry, but let's focus on my question. The injunctions were legal injunctions. They had legal effect. You couldn't disobey them. Is that right?
Well, it's claimant
The
submission.
injunctions. Yes. Is it your submission that do you agree that the injunctions had legal effect?
What claimant submits that or the decisions offered by the Senate would not have any legal effect.
Sorry, I'm asking about the injunctions. Did the injunctions have legal effect?
What claimant submits that the injunction may have legal effect, however, it would not have influence on the final decision made by the Senate.
Right, and the injunctions were a consequence of the Senatus Consultum. Is that right?
Yes.
They followed as a result of the Senatus Consultum.
Yes, claimants agree.
So the Senatus Consultum could not just have been political, as you submit. They must have had a legal effect as well, because they led to 2 temporary injunctions, not just 1, but 2. Would you accept that?
Well, even if the tribunal would, while we argue that it may only be the political effect of the Senate Consultum, as even as a political decision, it may lead to some, it may have some effect on the national system, that there may be injunctions issued regarding the political decision, and it's not necessary. Yeah.
Thank you. Thank you very much. Thank you. Please go on.
So even if the
Counsel, may I have a follow-up question? Do you have any view with regard to whether or not res judicata applies to preliminary injunction? Do you have any view on this issue?
Well,
you understand my question?
Well, it's claimant submission that res judicata.
Related question. Yeah.
Yeah, thanks for your question, Madam Arbitrator. It's claimant submission that res judicata only applies when the decision is a final and formal binding judicial decision. And for the preliminary injunction, since they are the interim measure offered by the tribunal, it would not have the binding effect and res judicata effect before the international tribunal.
What's the foundation? What's the foundation to support your argument?
Well, we rely on a case which is Carl Zeiss Stimfer versus Brennan and Keeler Limited, which it argues that for res judicata to apply, the decision must be final, and the preliminary injunction offered is not final.
Oh, but the decision of the Senate was final.
Yeah, thanks for your question, Mr. Arbitrator. Even if the decision of the Senate would be final, it is not a judicial decision. It's only a political advice, which has
Yes, just going back onto that, I think you have accepted that the injunctions have legal effect. In other words, as Dr. Reyes put it, you have to obey them.
But even if the injunctions has legal effect, it would not have a binding force before the international arbitral tribunals.
No, that's quite right. But my point is that the injunctions that were granted were looking ahead to the hearing before the Senate. So if the hearings which led to the injunctions being granted were themselves judicial proceedings in the sense that injunctions were granted, then if they were granted until the Senate hearing, doesn't it follow that the Senate hearing itself was a judicial proceeding?
where it's claimant's submission that the preliminary injunction is of temporal nature and it's under the influence of a political consultant offered by the Senate. Thus, it would not have any effect before the International Tribunal.
I see.
Do you draw a distinction between the senatus consultum and the praetor? It is the praetor who granted the temporary injunctions, and it may well be that the praetor, as a legal officer, has the power to grant such injunctions. But the senatus consultum may just be, as you make out, a consultation with the Senate. Is that your case, that there is a separation of powers between the senatus, the Senate, and the praetor? It's the praetor who grants the injunction using his legal authority. But that doesn't say anything, or we can't draw any inference from that as to the power or as to the effect of the decision of the Senate. Is that your case?
Yes, claimant argues that the Senate consultum is separate from the injunctions, and the Senate consultum, as argued by respondent, would not have any legal effect, any binding legal effect, and it is irrelevant in the case whether there are two preliminary injunctions offered or not.
Now, do you accept the respondent's argument that effectively the parties are the same? Do you agree with that, or do you disagree with that, and why?
Well, claimant would not. Claimant would not raise objections regarding this point, because we would not dive into the three requirements, the triple identity test listed by a respondent. We would only say that the Senate consultant would not have any res judicata effect, and we will not dive into the three requirements. Since the Senate consultant is first a political device, and second, it's a domestic decision that would not have any binding force of the exit tribunal, and these 2 points are sufficient to establish that the Senate consultant would not have a res judicata before the International Arbitral Tribunal.
Thank you. Could you just elaborate, why do you say that the senatus consultum would have, even if it were binding, even if it had legal effect, that's not your case, I understand, but you're saying even if it had legal effect, it would not be binding on exit tribunal, it would not be binding on us. Why do you say that?
Yeah, because, thanks for your question. It's claimant's submission that the Senate consultum is a domestic decision, and the domestic decision would not have binding effect over the International Tribunal, because according to Article 41, Section 1 of the Exit Convention, the tribunal shall be the judge of its own competence, and the exit tribunal shall not be bound by any national decisions. This is because the national legal orders and the international legal orders are distinct legal systems with different scopes, with different enforcement mechanisms, and different sources. Then the International Tribunal is also considered to be hierarchically superior to any national court or any national court or domestic court. Thus, the award made by a national court or made by a national branch would not have any res judicata effect before the exit International Tribunal.
Thank you.
And if that answers...
So is that your, is that your argument that triple identity test is not that irrelevant with res judicata principle?
It's not our argument that triple identity test...
It seems... Okay, please.
Thank you for your question, Madam Arbitrator. It's not our argument that the triple identity test is not relevant in the present case. However, we would not need to dive into these three requirements, since a national political decision would in any sense have no res judicata before the tribunal, and whether or not the triple identity test is certified would not change the fact that a national decision made by the Senate would not have such effect. So if that answers your question.
Okay, please.
So if that answers your question, I will move back to my third submission. And moving to our third submission, claimants submit that even if the Senate decision would have a res judicata effect, Prian could be sued for an investment made outside the province
made outside the city of Priene, which is located in the province of Asia. We argue that respondent has a right to sue according to Article 9 of the Bilateral Investment Treaty, and I quote, "The provisions of this agreement shall apply to any investment of an investor of one contracting party in the area of the other contracting party." This indicates that the investment made within the territory of the contracting party would be a qualified investment. Thus, my client could sue Priene for the investment in accordance with this territoriality principle, even if the tribunal were to determine that the contract in Priene falls outside the scope, the salt pans in Priene falls outside the scope of the contract. And moving to our third submission, it's a claimant's submission that whether the salt pans belong to the scope of the contract is a merits question rather than a judicial question. Thus, the tribunal should not open this issue in the judicial phase. And for jurisdiction, claimant submits that we have already established a prima facie jurisdiction, and regarding the applicable standard of the prima facie test, we recommend the tribunal to adopt the test derived from the oil platform case decided by the ICJ in 1996. In this case, the tribunal stated that to establish a prima facie case, the tribunal should consider whether the alleged violations do or do not fall within the provisions of the treaty. And Judge Higgins, in a separate opinion, further stated that the court should assume the facts provided by claimant to be true. And since in the present case, assuming the facts provided by claimant is true, claimant has already been affected by the deprivation of its operation rights regarding the salt pans in Priene. Such violations are capable of falling within the provision of the Bilateral Investment Treaty. It could thus be concluded that claimant has already established a prima facie case jurisdiction. Thus, claimant has satisfied this standard. And if I could be of no assistance to the tribunal, that would conclude my submission regarding issue 2.
Thank you. Thank you.
I wonder if I could just ask a question of counsel, Mr. President.
Please do. Please go ahead.
And my question is this. If I understood your last point, your last submission, it's this. The facts are so tied up, the substantive facts are so tied up with issues of jurisdiction that it would be wrong for the tribunal to decide the issue of jurisdiction now. So long as a prima facie case is established, and you say there's a prima facie case for establishing jurisdiction, we should not finally determine the question of jurisdiction until we have found the substantive facts, because the merits and the jurisdictional issues are so intertwined together. We can just proceed on the prima facie finding of jurisdiction and make a definitive finding on jurisdiction
Right. Thank you. Thank you. Reply?
Mr. President, members of the tribunal, can you hear from the respondent clearly?
Yes. Yes. Can do, Ms. Chen.
Thank you. For rebuttal from the respondent will make 3 points. So regarding the judicial effect of the Senate decision, it was admitted by the claimant that the injunction does have legal effect, and that the injunction actually ultimately lead to the decision rendered by the Roman Senate. And second, and regarding this issue, the claimant, in fact, actually even asked for a security deposit until the Roman Senate's decision was finally decided. This can reflect that the Senate decision is final and binding on the Pubblicani and the claimant. And the respondent will be curious to ask, if the decision made by Roman Senate is not final and binding, why does not Pubblicani appear as an investor in front of this tribunal, but instead the claimant? And regarding the second point, the respondent was claiming that he can rely on the investment in the other parts of province of Asia against the respondent. However, the investment made by the claimant in other parts of Asia is domestic in nature and does not involve investment disputes that is international. And regarding the third point, the prima facie test, this test does not apply in the present dispute because that test only concerns whether there is an existence of any treaty obligation violation, whereas in our case, the question is whether there exists an investment, and that is decisive and determinative for the jurisdiction of this tribunal. And that concludes all my rebuttal. Thank you.
Ms. Chen, can I just ask you one question? You have said more than once that the claimant has admitted that these hearings were judicial hearings. Do you mean by that they merely participated? I mean, where does the admission come from? I don't see anything to indicate their admission.
Mr. President, thank you for your question. It was respondent's submission that the claimant has admitted the injunction may have legal effect, and it can be inferred that if the injunction would be legal in nature, and then the Roman Senate decision would be legal as well. Thank you.
Thank you. I understand that. I understand. Thank you.
So, may I have a question for the council? Roughly, I have the same question directed to you. What's your view on the question as to whether or not a provisional, in this case, the preliminary injunction measures, whether or not these kind of measures constitute res judicata?
To address. Thank you for your question, Madam Arbitrator. To address your concern, the respondent submits that the preliminary injunction does not itself constitute res judicata effect because it is not final. However, the respondent submits that the Roman Senate decision, even though claimed by the claimant that is only in nature and advice, the praetor actually must make decision based on the advice of the Roman Senate. And in that case, the decision itself has a res judicata effect on the claimant.
But you admit that those decisions are still, in their nature, coming from the provincial measures. Do you accept that?
Madam Arbitrator, it is the respondent's submission that those two injunctions were a wait for a final decision made by the Roman Senate.
Yes, thank you. Thank you. Any rebutter or is that it? No more submissions?
Yes, President Arbitrator. So I will start my rebuttal now. So, and to respond to respondent's rebuttal, first, we argue that the Senate consultum is only a political decision, even if it leads to two preliminary injunctions. It will not change the fact that it is a political decision, because due to the political influence that leads to the two preliminary injunctions, and will not change the fact it's not a judicially binding decision before the exit tribunal. And second, in response to respondents' questioning why it is not the publicani participating in this proceeding, we argue that the publicani in the Roman Senate in the Roman stage lacks a legal personality at that time, so it could not participate in any proceeding together. And second, regarding whether it is a merits question or a jurisdictional question, we argue this is a merits question. Respondent submits that the prima facie test only applies when there would be a violation of a bilateral of a bilateral investment treaty, and we argue that the scope of a contract is a very important basis to establish any violations of the BIT, since it would directly related to whether there exists expropriation in the present case, or whether there exists a breach of contract obligations that would finally constitute a violation of a bilateral investment treaty. Thus, the prima facie test could be applied in the present case. And that concludes my side rebuttal. Thank you.
Can I ask one final question from me? You talk about these being political bodies or political appointments. I'm just looking at, if you look at paragraph 28 of the case study, which is on page 6, talks about the provinces being governed by pro-magistrates, at that time proconsuls or proprietors, by men that had served as praetors or consuls in the year before. Now, this is the sort of Roman government structure, and it seemed that as part of their governing powers, can we not infer that they also had judicial powers?
Thanks for your question, Mr. President. And it's claimant's submission that the Article 28 only reflects the administrative hierarchy between inside the Roman Empire, and we argue that the praetors and consuls are only administrative stuff of the Roman Empire, which would not have any judicial power in the present case.
But they had power to grant injunctions.
Yes, and if the tribunal is not with my previous answer, I could offer the tribunal with authority, which is written by an Anavitata EJ, which it argues that in ancient Rome, that the forcible decisions was only due to the political influence, but not based on any legal test. Thus, we could conclude from this authority that at that time the praetors and consuls would not perform any judicial obligations. Thank you.
I understand. Thank you. I think that then concludes the oral arguments. Am I right? And it probably then falls for us, the judges, the arbitrators, to.
I think we still have
issue 8.
Issue 8.
I think there's 15 minutes for each team on issue 8.
Oh, do we? Oh, right. Okay. Sorry, my mistake. So who's going to start off on issue 8?
Mr. President, the respondent will start on issue 8.
Right.
Mr. President, members of the tribunal, I'll be addressing issue 8 on behalf of the Roman Republic in accordance with the clarification rules. Members of the tribunal, the dispute between the claimant Mr. Pomponius and the city of Priene is supposed to be a domestic dispute. More than 40 years ago, Rome has succeeded the kingdom of Pergamon and has exercised sovereignty over the city of Priene ever since. Under issue 8, the Roman Republic submits that the city of Priene does not have a standing in this dispute. And to support that, Rome will make 3 submissions. Number 1, the standing of the city of Priene can only be established either as an annexed member state or as a subdivision designated by a member state of exit, and the city of Priene has failed to establish either. Number 2, not approving Priene to exit arbitration will not deprive the foreign investor of protection. And number 3, the partial award does not apply in the present dispute. Moving into our first submission, the city of Priene lacks standing either as an annexed member state or as a subdivision of a contracting state under Article 25.3 of the Exit Convention. There are 3 reasons, 3 aspects which the Roman Republic will address respectively. So number 1, The city of Priene is never a member state to the ICSID Convention, and there is no automatic membership succession in ICSID Convention. This can be found in the example of the secession of Czech and Slovak Federal Republic. In that case, the two new states have joined the ICSID Convention through a reapplication procedure as new parties. And in the present dispute, because the city of Priene never applied to the ICSID to become a member state, it does not have a standing as a member state. And moving on to our second aspect, the city of Priene does not have a standing as a subdivision of the Kingdom of Pergamon under Article 25.3 of the ICSID Convention. Article 25.3 of the Convention allows the territorial units of a state to consent to arbitration without the approval of the contracting state. It is important to emphasize that the source of the right of the subdivision to have a standing in an ICSID arbitration comes from the rights of a member state. And in our case, since the Kingdom of Pergamon no longer exists, the notification itself under Article 25.3 would also cease to have effect. And if the tribunal ultimately decides that Pergamon could create an independent standing for the city of Priene using this notification coming from the Kingdom of Pergamon, this would circumvent the rules of the ICSID Convention on the membership. In accordance with Article 67 of the ICSID Convention, for parties to join to become a member state, it must either be a member state of the World Bank, or it was subject to the 2/3 of the vote from the Administrative Council. And this would amount as that Priene would enjoy its standing of a member state without becoming one, without going through the formal procedure. And moving into our third aspect of Priene's lack of standing, even if Priene believes that the notification made under Article 25.3 of the Convention should be succeeded by Roman Republic and continues to apply, the requirement of difference in nationality would not be satisfied. In accordance with Article 25, Paragraph 1 of the ICSID Convention, it is stated that the jurisdiction of the center shall extend to any dispute between one contracting party and a national or any constituent subdivision and the national of another contracting party. If the city of Priene believes that the Roman Republic has succeeded such notification, the nationality of the investor and the city of Priene would be the same. It would both be Rome.
Can I just interrupt here, Council? My concern is this. If you look at paragraph 23 of the case study, that states that both, well, let me read it out. Both an honorary decree for Apollonius of Metropolis, as well as the speech of Marcus Antonius in 41 BC, state that the cities, polis, of the Kingdom of Pergamon, including Priene, had been given the status of free cities after the death of Attalus. It is unknown whether Attalus granted this in his state testament, and that the Senate of Rome only ratified Attalus's will, or the Senate of Rome itself granted this freedom. For the purposes of this move, participants will assume it was done in execution of the testament of Attalus. So does that not imply that although Rome may have conquered the rest of Pergamon, the city of Priene remains a free city, as stated in the will of Attalus, under which the claimant is making its claim, and it has independent status from Rome, and therefore is an appropriate party. Would you accept that?
Mr. Arbitrator, Roman Republic would not accept that. There are two reasons. So number one, the city of Priene has never being a sovereign state, but a part of Roman Republic. This can be shown that in the footnote, in footnote 61 on page 10, this footnote reflects the customs law of Asia. And at that period of time, the Roman law applies to the city of Priene. Besides this, if I may invite members of the tribunal to page 24 of the casebook.
Does that answer my question, really, counsel? Because English law, or the common law, applies to many different countries. But it could not be said that those countries were still under England after the period of decolonization. So the fact that Roman law applies widely, indeed still applies today, has nothing to do with whether a state is able to mount a claim independently of Rome.
Mr. Arbitrator, to answer your question, while it is the fact that English law applies beyond the scope of just England, the judicial jurisdiction would be one of the factors to be taken into consideration in judging whether the city of Priene has its independent status or not. And in fact, the Roman military also has its presence in the city of Priene. Even though it enjoys a high degree of autonomy, it would still be under the sovereignty of the Roman Republic. And after I finish this first layer, the second layer of my argument is that even if the city of Priene could be proven to have an independent status, it also needs to reapply to the ICSID to become a new member. So with those two reasons, the respondent submits that the city of Priene does not have a standing in this case.
Right, thank you.
Counsel, about your requirement to reapply, what was the situation after the dismemberment of the Soviet Union or of Yugoslavia as to the ability to plead or not to plead in the ICJ?
Thank you for your question, Madam Arbitrator. As for the situation of Soviet Union, because it was never an ICSID member at the first place, so even though the BIT continues to apply to its former republic, the fact—
Counsel, I didn't ask about ICSID, I asked about the ICJ.
Madam Arbitrator, sorry, would you mind clarifying your question?
You said they need to reapply. I asked you what was done in the case of the dismemberment of the Soviet Union and the dismemberment of Yugoslavia as to their respective memberships to the ICJ.
Madam Arbitrator, it is respondent's submission that different international organizations or treaties has different requirements. In this case, because an investment arbitration is concerned, we should look first at the practice from the previous ICSID member states and not the ICJ cases. And if we look at the ICSID practice, in the case of Yugoslavia, it is also the case that the new states, after the separation of the previous state, that the new parties have reapplied to become member states of ICSID. If I cannot be of further assistance, the Roman Republic will move on to our next submission, that disapproving the standing of Priene does not prevent the investor from seeking other recourses under the BIT. According to the succession agreement between Pergamon and Rome, the BIT will apply with full force for perpetuity, and disapproving Priene's standing would not defeat this purpose. The only change would be the legal nature of the instrument of the BIT from international agreement on a national arrangement between the central government and the local government. And revoking the notification of Priene would not render the treaty provisions invalid, and there are other routes of protection, including negotiation, domestic litigation, as well as on-sitio arbitration. And moving into our last submission, the partial award here in this case does not apply because for two reasons. So number one, that partial award does not have any binding effect or precedent effect on this tribunal. And number two, to distinguish the facts between that award and the present dispute. The partial award is a state-to-state dispute, whereas in this one, we're facing an investment dispute. And no exit membership is involved in that case. And also, in that case, even the tribunal the sole arbitrator has determined that all cities must collectively represent the interest of the dissolved mother state. And in our case, the other three cities were not even notified of this proceeding. And for those two reasons, that partial award does not apply to determine the standing of Priani. To sum up, for that, the city of Priani cannot establish its standing as an independent state or as a subdivision of neither Roman Republic or the Kingdom of Pergamum. The city of Priani does not have a standing in this case, and Roman Republic urges the tribunal to dismiss all of claimant's claims. Thank you.
Yes, thank you. Claimant?
Can the tribunal hear claimant clearly?
Yes. Thank you.
Greetings to Mr. President, members of the tribunal. My name is Yu Yingke. On behalf of claimant, on behalf of respondent, the city of Priene, I would plead for issue 5 and present the main arguments. My co-counsel, Ms. Chen Lingwen, will represent claimant, Titus, and make supplementary arguments. The question issue 5 poses before this tribunal is whether the city of Priene has the standing to be a party before the center, given the fact that its predecessor state, the Kingdom of Pergamon, has been incorporated into the Roman Republic. Against this background, the city of Priene makes the following submissions. Our roadmap is first, pursuant to Article 25 of the Exit Convention, Priene stands on its own right to be a proper party in an exit arbitration. And second, Priene submits that such a notification made by the Kingdom of Pergamon remains valid, and that Priene retains the right to be a party till this day because it was the parties' mutual agreement. Coming to our first submission, which is that the city of Priene stands on its own right to be a party in an exit arbitration. Under Article 25, Section 3 of the Exit Convention, for a subdivision of state to enter into arbitration, two requirements should be fulfilled. Number one, the state should designate the subdivision to arbitration, and second, the state should approve to it or notifies the center that such approval is waived. Priene therefore submits that in the instant case, both the criteria have been satisfied. First, as for the approval requirement, the Kingdom of Pergamon has provided for in the case study, has notified the center that it would waive approval in respect of Priene's participation in exit arbitration. And second, as for the designation requirement, such a notification made by the Kingdom of Pergamon could be regarded as designation. In Nichols Resources' case, the tribunal found that the state of Bangladesh should be deemed not only to have approved consent to the exit arbitration by these two agencies, but also have designated, since it has explicitly notified the center. Combining these two factors, the city of Priene contends that its predecessor state, the Kingdom of Pergamon, has made Priene has the right to stand on its own right to be a proper party to the Exit Convention. The second question the tribunal needs to contemplate is whether such notification, which grants the city of Priene its own right to stand before an exit tribunal, still stands till this day. And to that, the city of Priene would encourage this tribunal to look directly at the contracting party's intentions. Above all, the city of Priene would like to kindly remind the tribunal of the fact that neither the Exit Convention nor the Exit Arbitration Rules contain provisions dealing directly with this question, since the case at hand, we must admit, is an extremely complicated case that has no precedents. The case is composed of various complicated events, including incorporation, state succession, the continuity of bilateral investment treaty within the territory of one sovereign state. There are no international practices that the tribunal can find guidance to, or customary international law that specifically deal with this issue. Therefore, the city of Priyan would encourage this current tribunal to follow the general international practice, namely to look directly at the party's intention on Priyan's standing in front of exit tribunals. This contention is based on the previous international practice we could offer to this tribunal. For instance, the practice between Chinese mainland and Hong Kong and Macau and its transfer, and second, the standing of the Free City of Danzig and the state of Poland. In respect of the first instance, the parties, the Chinese government and the English government, envisaged that the 1984 UK-China Declaration. Is there a question? Okay. The 1984 US-China Declaration states that international agreements to which the People's Republic of China is not a party, but which are implemented in Hong Kong, may remain implemented in the Hong Kong. This specific representation is against rules of customary international law, as the tribunal might be familiar with the moving treaty frontiers principle, which means that when a ceded territory is transferred into another sovereign state, the treaties to which that successor state shall extend to the ceded territory. However, this rule of customary international law does not automatically apply to the situation in which the Chinese mainland and Hong Kong is involved, because Hong Kong, as a special entity within the Chinese constitution, the Chinese government and the English government made a special representation, and they have reached an agreement regarding the issues. Therefore, under this international practice, the tribunal can see that when lacking specific regulations, the tribunal should resort to the direct intentions of the parties. The second example we would like to offer for the tribunal for contemplation is the Free City of Danzig and its special relationship with the government of Poland. The International Law Commission was once asked by the United Nations to draft an advisory opinion on whether the Free City of Danzig would retain its membership in the International Labour Organization. This question was asked to be resolved by the International Commission because there are no specific rules dealing directly with the special status of a free city. In its contemplation, in its advisory opinion, the International Law Commission first examines whether the Free City of Danzig and the government of Poland have an agreement regarding this issue. By looking at the treaties signed between Poland and the Free City of Danzig, or the statements made between these two entities, the International Law Commissions reached the conclusion that given the negotiations and fixations by those two entities, the Free City of Danzig would not be a proper party to be the International Labour Organization. From these two international practices, claimant relies on these two international practices to urge this tribunal also to look directly into the original intention of the contracting parties, namely the Kingdom of Pergamon and the Roman Republic. Based on this premise, we would encourage the tribunal to follow us to page 2 of the case study. Apologies, page 4 of the case study. In page 4 of the case study, paragraph 19, it reads, as Respondents' Council has pointed the tribunal's attention to, the agreement between the Roman Republic and the Kingdom of Pergamon on the promotion and protection of investment shall continue to apply with full force in perpetuity. On the same page, above paragraph 18, the inscriptions, the translation of the inscriptions as to the decision made by the Roman Senate, the second paragraph. The Roman Senate, the highest authority then, states that what was given away, directed, fixed as punishments, given by King Attalus and the other kings, shall remain valid. Given this decision made by the Senate and the King's testament that the BIT shall continue to apply with full force in perpetuity, we can conclude that the that the Kingdom of Pergamon and the Roman Republic had reached a mutual agreement regarding the application and continuity of the BIT. Now, if the tribunal would please follow me to dive into the details of the BIT and see how it regulates preends or subdivisions within the Roman Republic its standing to stand before the exit tribunals. If the tribunal would please look at Article 10 of the BIT.
I just interrupt you, counsel. And could I just get clear the chronology of the matter? When the application was first made, the notice of arbitration was submitted to ICSID, had Pergamon been absorbed into the Roman Republic?
Yes. When the arbitration is initiated, the Kingdom of Pergamon has already been absorbed into the Roman Republic.
When was Pergamon absorbed into the Roman Republic?
It was in...
So first, when was the notice of arbitration sent?
It was sent in 90 BC.
90 BC.
Yes.
And when was the Kingdom of Pergamon absorbed into the Roman Republic?
It was in
88 BC.
The Kingdom of Pergamon was absorbed into the Roman Republic by the execution of the Testament, which was in 132 BC.
BC, yeah.
Sorry, but by the execution of the Testament, you say?
Yes.
And that's Attilus's Testament, is it?
That's right.
Yeah. This is paragraph 12, is it? Paragraph 12 of the case study.
Yes. Does that answer?
That was brought. And just show me where it was absorbed into the kingdom.
Page 3 of the case study, Mr. Arbitrator. Page 3 of the case study, paragraph 17. Yes. In 132 BC, the Senate accepted the inheritance. The inheritance refers to the testament made by King Attalus III, which was in 133 BC, stating that he would left his kingdom and his royal assets to the Roman Republic.
Right, because it seems that he also guaranteed the free cities, the freedom of the cities at the time.
Yes, that's right.
The freedom of Praene at the time. So is that not a carve-out from what he was giving to Rome?
That would depend on the tribe.
As a matter of construction, how can we have both? He's giving everything to Rome, at the same time he's confirming, ratifying the freedom of the free city, the freedom of the cities within Pergamon.
Yes, that would depend on our and the tribunal's definition of what a free city means under international law.
What I'm asking is, what is your interpretation?
Yes, our interpretation is that we do not challenge Roman Republic sovereignty over the free city of Priene, because we do not contend that Priene stands on its own right as a subject in international law. It retains a special status as free city under the sovereignty of Roman Republic.
Right, so you accept that Rome has dominion over Priene and has had that since the time of the Testament. The Testament was accepted or ratified by Rome.
Yes, but our admission to this. Yes, but our admission to Roman Republic sovereignty would not impair the city of Priene's standing before an exit tribunal. If the tribunal would please follow me, resume to Article 10 of the BIT. Article 10 of the BIT.
Before you move on, can I just clarify one thing? You are saying Priene is or is not part of Pergamon?
Priene was a part of this kingdom of Pergamon and was later transferred to Roman Republic according to the King's Testament.
And therefore, is it or is it not now under the Roman Republic?
It is under the Roman Republic.
So Priene is in the Roman Republic, according to your case?
Yes.
All right, move on.
The fact that Priene is under the sovereignty of Roman Republic does not affect its right to stand before an exit tribunal. If the tribunal would resume to Article 10 of the BIT between Roman Republic and the Kingdom of Pergamon, Article 10, Section 2, which is the settlement of investment disputes. It reads, if any dispute between an investor of one contracting party and the other contracting party cannot be settled in such a manner the investor shall be entitled to refer the matter to the ICSID for arbitration. As Respondents' Counsel has just submitted, the BIT would apply in full force, including Article 10, Section 2 of the BIT, which means that each contracting state, either the Roman Republic or the Kingdom of Pergamon, the investors of these two contracting states, shall have the right to initiate an arbitration under the ICSID. We would argue that this fixation by the Kingdom of Pergamon and the Roman Republic shall be viewed by the current tribunal as a mutual agreement regarding Prien's standing to sue, regarding Prien's standing to have the right before an ICSID tribunal. This is because...
Right, and just to clarify, you referred a moment ago to Article 25(3) of the ICSID Convention. Consent by a constituent subdivision or agency of a contracting state shall require the approval of that state unless that state notifies the center that no such approval is required. And how did you say the approval was given by the Roman Republic?
We do not...
What notification was given that no approval was necessary?
It is Prien's submission that we do not need notification from Roman Republic because our predecessor state, the Kingdom of Pergamon, has made such a notification, and we submit that such notification still remains valid due to the fixation and the mutual agreement within by the Roman Republic and the Kingdom of Pergamon, since it ensures that the BIT would apply in full force in perpetuity, which means that each contracting party, the investors of each contracting party, shall still bear the right to initiate an arbitration under ICSID. Because Roman Republic's...
So you're saying that by ratifying the testament of Attalus and effectively which made the BIT apply in perpetuity, that was effectively a signal or notification by the Roman Republic that it was unnecessary for approval of the Roman Republic to Priene acting on its own so far as the ICSID Convention is concerned. Is that your case?
Yes, that would be our interpretation. It is because when Roman Republic consent to the continuity of the application of the BIT in full force, it should be regarded by the tribunal as consent to the continuity of Prien's legal status before the ICSID Center. This is because if the BIT were to apply in full force, the investors of Roman Republic shall always have a right and access to initiate an arbitration before ICSID Tribunal. And as well, the Kingdom of Pergamon or subdivision of the Kingdom of Pergamon shall also have the legal standing before ICSID. Similarly, investors who is resident of Prien should also have the right to be protected under the BIT and bring an arbitration under ICSID for such right to be protected. Otherwise, if the investors of the Roman Republic or Pergamon does not have the right or standing to sue in front of an ICSID tribunal, such perpetuity in full force with the BIT would not be validated. It is against the party's original intention, since as fixed by the Roman Senate's decision that what was given away and fixed by the king shall remain valid till this day. Therefore, we conclude that this mutual agreement shall be interpreted by the current tribunal as a negotiation and agreement regarding Prien's continuing legal status before the ICSID tribunal, since, according to international practice, when lacking specific rules dealing with a complicated situation, the original and direct intentions of the parties shall be adopted by the tribunal. And with that, I conclude my submission. Thank you.
But if I could just ask a little bit more, because it's a very interesting question. What do you say is the nationality of the Priene citizens of Priene at this time? They're Roman citizens. Is that your case?
Yes, because we respect the sovereignty of Roman Republic over the city of Priene.
So that they are Roman nationals.
Yes.
You accept that. And just looking again at Article 25(3), I read out Article 25(3), consent by a constituent subdivision or agency of a contracting state. I may have read it out of context. That refers to the consent, among other things, referred to in Article 25(2)(a) and (b). Am I right on that?
Yes.
You'll see that the word consent is used in Article 25A and B.
Yes.
And it is in that context that the word consent in Article 25(3) should be read. Would you accept that?
Yes.
All right, thank you.
Council, I have a related question. Since you repeatedly talk about the intention of original parties to the BIT, so since we know that Kingdom of Gammon does not longer exist, so I'm wondering, how do you understand at this current stage, is there still common intention there, or is that should be different interpretation with respect to so-called common intention of the parties to get?
I'm sorry, Ms. Arbitrator. If I understand your question clearly, you're asking whether the membership of the Kingdom of Pergamon still exists in ICSID?
No, I'm asking, since you talk about the intention of the original parties to the BIT. So you know, one of the original parties, which is Kingdom of Gammon, does not exist anymore. Does that affect how to interpret or understand the common intention of the original parties?
Yes, thank you for your question. The city of Prien's position is that although the Kingdom of Pergamon no longer exists in this day, its intention can be read by the King's Testament, which reads, as the tribunal has also read, that the BIT shall apply with full force in perpetuity, which was also confirmed by the Roman Senate. This testament and the confirmation coming from the Roman Senate shall be read by the tribunal as a mutual agreement by the Roman Republic and the Kingdom of Pergamon fixed at the time when the Roman Senate made this confirmation that the BIT shall apply in full force and perpetuity, including Prien's legal status before an ICSID tribunal.
If I might follow up on Professor Shi's question, if you look at the preamble, the ICSID Convention, do you accept that we have to construe the convention, or we can construe the convention, in light of the preamble? That would be legitimate under the Vienna Convention. Would you accept that?
We accept.
If you look at the second declaration, second recital of the preamble, contracting states, bearing in mind the possibility that from time to time disputes may arise in connection with such investment between contracting states and nationals of other contracting states. My difficulty, and I think what Professor Shi was getting at, is at the time that you identified, you said that by the time the notice of arbitration was put in, Pergamon had been absorbed into the Roman Republic. Priene citizens and Roman nationals, the claimants, were all Roman nationals. They're not nationals of two different contracting states by the time. So the ICSID Convention just simply wouldn't apply to this claim at all on the basis of the second recital of the preamble. Would you agree with that?
Yes, we understand your concern that the divergence of nationality requirement, which is also stipulated in Article 25, Section 1 and A of the ICSID Convention, would apply to this case. We would argue against this application because the tribunal must acknowledge the special character of the city of Prien, that it's a free city. Although the existence of free city cannot be seen in the international community today, the tribunal should refer to other practices. For instance, the legal status of the free city of Danzig just before this entry, and then read and take the free status of the free city into its contemplation on its application of the ICSID Convention, since we are dealing with a case that happened in a historical sense. The special character of the city of Prien, that namely its special status of a free city, would not strictly fall under the requirement of divergence of nationalities, the tribunal must acknowledge and take that into its contemplation.
Now, you say that there are no free cities today. Is that your case? Say, for instance, the Vatican, would you consider that a free city? San Marino, would you consider that a free city? Andorra, Liechtenstein.
I think in this case, the facts show that there are free cities. I think there's a limit to how far we can take this, because the facts show that Priene was a free city. Paragraph 23 of the case study shows that. And that's confirmed by the Senate at Rome. So, in other words, the sovereign has carved this out. I think we're getting further and further away from the jurisdiction issue.
I apologize then. Would counsel proceed then, please?
If there are no further questions, that would have concluded my submission. Thank you.
Thank you.
I think there's a reply coming.
Yes, Mr. President. On the issue just mentioned, the respondent will make 3 points for rebuttal. So first, given there was already a discussion in terms of the lack of divergence of nationality under Article 25(1) of the Exit Convention, the Council for Respondent will focus on the 2 other points. The first is that the claimant, the city of Priene, has argued that intention of the parties between Rome and Pergamum. However, in that agreement, in the testament or the ratification, it was never stated expressly that the city of Priene would have a standing in front of an exit tribunal. The only thing that can be read was that the BIT would be applied in force with perpetuity. However, the validity of the BIT today still is not affected. And given that the legal personality of Pergamon had ceased to exist, the notification made by Pergamon should not exist either. This is based on the UN 6 Committee principles. And regarding the last point on treaty succession, the case given by the city of Priene, the Hong Kong and Macau case, the declaration only concerns the succession of the treaty and not exit membership or notification. And actually, regarding the notification, before 1997, the UK did designate Hong Kong as a subdivision. However, this designation or notification was never succeeded by China after 1997. And with those 3 points, the Roman Republic will conclude its submission.
Yes, thank you. Now, what's left? I think that is the end of submissions.
I think there's a sorry button.
I think we've almost exhausted the sorry button. But is there a sorry button?
If the tribunal would permit.
Yes, of course.
Thank you. 2 points for rebuttals. The Respondents' Council has also acknowledged that the original intention of the parties should be taken into consideration. However, she explicitly points out that the continuity of the BIT would not be affected, given that the parties should still have the rights. She specifically points that the continuity of the BIT does not mean that Priene has the standing before an exit tribunal. That we consider is a contradiction, since if the BIT were to apply in full force, including Article 10, Section 2, then Priene, as a subdivision of the Kingdom Pergamon or as a representative of the Kingdom Pergamon, shall have the right to stand before the exit tribunal. And the second is that the Respondents' Council has pointed out to the fact that the UK that the Chinese government did not that Hong Kong did not succeed indeed UK's destination to it before the exit. However, this corroborates our point that what was fixed by the two governments shall remain fixed and respected by tribunals. So it correlates to our submission that the tribunal should look directly into the intention of the parties and make them remain fixed. That concludes my rebuttals. Thank you.
Thank you. Any questions or any other submissions? I think we next go to
feedback, I believe.
Sorry?
Either feedback or deliberations. I don't know which one
I
is
think
first.
we should have a deliberations first. Do we go to a breakout room? I mean, is the secretary there?
Yes, the secretary is present.
Secretary, can you hear us?
Can we go to a breakout room, please? I think we're not in a breakout room because I think the claimants and the respondents can hear us.
Recording stopped.
中国国际经济贸易仲裁委员会，1956年以来，当事人涉及100多个国家和地区，受案量位居世界前列。根治中国，服务全球。
中国国际经济贸易仲裁委员会是中国第一家仲裁机构。60多年来，贸仲不仅培养出了大批优秀的中国国际仲裁员，而且为中国仲裁立法的制定和完善及中国仲裁乃至世界仲裁事业的发展做出了重要贡献。
1956年，对外贸易仲裁委员会由中央人民政府政务院批准成立，中国仲裁事业由此开端。1986年，贸仲以国际化的事业推动中国加入纽约公约，使中国的仲裁裁决可以在纽约公约现今150多个成员国得到承认和执行。1994年，中华人民共和国仲裁法颁布，贸仲长期的仲裁实践和先进的仲裁规则，为仲裁法的制定提供了重要参考和借鉴。同年，贸仲与国际商事仲裁理事会首次在北京举办国际商事仲裁立法大会。2004年，贸仲在北京举办国际商事仲裁理事会第17届国际仲裁大会，世界5大洲47个国家和地区的500多名仲裁法律专家与会，进一步提升了贸仲在国际仲裁界中的地位和影响。贸仲以其独立公正、快捷高效的仲裁服务享誉全球，近10几年来，受案量一直在国际仲裁机构中位居前列，打造了中国仲裁的国际品牌，形成了国际仲裁的中国经验。
60多年来，贸仲始终坚持为当事人提供独立、公正、快捷及高效的国际商事仲裁服务，建立了裁决书核阅、专家咨询等独具特色的业务管理制度，制定了完善的业务管理规范和成熟的办案流程，首创了仲裁与调解相结合的仲裁实践，被国际仲裁界誉为东方经验。
中国国际经济贸易仲裁委员会成立至今，先后颁布实施了9版仲裁规则。现行有效的规则是2015年1月1日起实施的仲裁规则。2015年3月1日，贸仲制定的证据指引发布实施，填补了国内法律有关仲裁证据规则的空白，为规范仲裁程序、确保裁决质量、提高仲裁公信力提供了重要保障。为更好地服务当事人，中国国际经济贸易仲裁委员会不断加快机构建设，完善网络布局。2012年，贸仲香港仲裁中心的设立，成功开创了一委两制的仲裁实践。2015年，特别设立海峡两岸仲裁中心，专门服务两岸经贸等争议解决。2015年底至2016年，贸仲先后设立了贸仲福建自贸区、广东自贸区和天津自贸区仲裁中心。中国国际经济贸易仲裁委员会拥有一支国际化、高水准的仲裁员队伍，现有仲裁员1200多名，其中外籍港澳台仲裁员共300多人，占总数的1/4以上。外籍仲裁员来自世界41个国家和地区。贸仲实行专业经办秘书制度，由业务素质高、实践经验丰富的经办秘书协助仲裁庭处理案件的程序管理工作，为仲裁程序的快捷高效提供了重要保障。除了做强仲裁主业外，中国国际经济贸易仲裁委员会还积极促进争议解决服务的多元化，先后推出网上仲裁规则、建设工程争议评审规则，成立网上争议解决中心、投资争端解决中心，为国内外当事人提供以商事仲裁为主的多元争议解决服务。作为中国仲裁的领军机构，贸仲还主动承担行业责任，积极发挥公共服务职能， 承办重大的国际仲裁会议，搭建国内外仲裁界的交流平台，主办中国仲裁周、中国仲裁高峰论坛、国际商事仲裁模拟辩论赛等活动，大力推动仲裁理论研究，积极参与仲裁法及相关法律或司法解释的修订工作，促进仲裁制度的完善。2015年，中国国际经济贸易仲裁委员会管理的近2000件仲裁案件，平均结案时间为组庭后143天，其中占案件总数67%的简易程序案件，平均结案时间为组庭后104天，体现了贸仲机构管理的优势和仲裁程序的高效。60多年来，贸仲共审结仲裁案件近3万件，当事人涉及100多个国家和地区，已成为世界上最重要、最有影响力的国际商事仲裁机构之一。
CTAC has enhanced its ability to serve the needs and expectations of parties from all over the world by adopting an internationalized approach in its arbitration rules and case administration. I am aware that there has been an increase in the volume of CTAC cases conducted in English or bilingually, as well as cases where both parties are non-Chinese, where foreign arbitrators sit on the tribunal, and even cases seated outside mainland China. The increase in such cases reflects a high degree of confidence in CTAC's internationalized approach.
中国国际经济贸易仲裁委员会利用自身的国际地位，积极参与国际仲裁规则制定。自2009年开始，贸仲作为联合国国际贸易法委员会的非政府组织观察员，深度参与仲裁和调解、网上争议解决、投资争端解决等重要议题的审议，在国际舞台上代表中国发挥积极作用。同时，贸仲广泛开展国际仲裁交流，先后与近50个国际知名仲裁机构签署了合作协议，开展多种形式的合作，致力于国际仲裁的融合与发展。
We're now back. Can everybody hear us?
Yes.
Yes. Claimant, respondent, everybody? So I think the results will be announced at the ceremony. What we're going to do now is the judges will give their feedback on the performance of both of the advocates for both parties. And perhaps I could start off with Ms. Cheng, Teresa Cheng.
Thank you. Thank you very much. May I just congratulate all the students for doing extremely well in both the preparation and the advocacy work that was being done. And I think you've all been very thorough with your analysis of the facts. And I think some of you have been very good at citing cases, and the way you've cited them directly relevant to the particular issues at hand becomes very useful. A little bit of, without being specific on any particular individuals, a few things that I would be able to observe would be, for instance, when the tribunal is asking questions, I think it's important to listen to the questions and as it were, accept them if they are correct, or disagree with them if they are not correct. It doesn't mean that everything we ask would be accurate, but that's something that's important. I think listening to the question is very important, announcing in a very direct way. Sometimes by restating your position or your case doesn't answer the questions, and that may not be very helpful. In terms of the way that you are delivering, I think it's been good. Try not to have too many hand gestures because it sometimes can be quite disruptive. So less hand gestures if you can. And then every now and then, of course, it's difficult, but I noticed that you're all focusing on the screen, which presumably all the 5 of us will be there. Reference to the facts are effective and very quick and succinct, and I think that helps us in understanding all of these matters. And in particular, I think a few of the questions are particularly difficult in the sense that they may not directly arise from what you have been looking at in the case, but I think the answers that have been given in answer to those questions are very encouraging, because obviously a lot of background, even though slightly marginally relevant, you have done the research on in order to answer the questions. So I think those are my brief comments, but may I say all of you have done extremely well, and thank you very much for such an enjoyable experience. I will have to drop the line because I have another matter to attend to, but thank you very much, all of you, and thank you for my colleagues for being such a great team to work with. Thank you.
Thank you, Teresa. Thank you, and goodbye. Have a good
Bye.
Having look at your presentation and your oral arguments, I'd like first as well, I think much of what I'm going to say is already said by Teresa. First, I would like to congratulate the 2 teams for finishing this, in my opinion, is not a easy journey. Compared to FBI, also in investment arbitration moot court, Frankfurt, this one, in my opinion, is much harder, because the story, the background was set up in this case is very ancient Rome, and you have to apply very contemporary international 21st century international law. So generally, I think you have, I totally agree, Teresa, 2 teams have performed very well. You have done a wonderful job. In the interest of time, I'm not going to one by one either. But if there is room for further improvement, from my personal perspective, I think you may look in.
中国国际经济贸易仲裁委员会，1956年以来，当事人涉及100多个国家和地区，受案量位居世界前列。根治中国，服务全球。
中国国际经济贸易仲裁。
Of 2 teams in terms of international investment arbitration. As a law professor in this field, I particularly encourage you. I think what you are doing today is not only, hopefully not only for this moot court competition. I do encourage you keep enduring interest in this field. Although it's not very, very popular compared to commercial arbitration. I hope you can do well in the next step. I'm very glad having this journey with you. Thank you so much. Thank you so much for having me.
Thank you, Jinxia.
I have to drop the line as well. Okay, bye for now.
reply.
Bye now. Enjoy your weekend. Anselmo, please.
Thank you very much. First of all, I would very much like to echo the praise that has been heaped on both teams by Teresa Cheng and by Professor Jing Shashi. I think that the performance of both teams has been excellent, and the members of the team should be very proud of that. I regret very much that as we are still living in the after effects or the post effects of COVID, I'm not able to be there in person, but I hope in the future that I will be able to meet you in person and to congratulate you in person myself. I apologize as well for asking difficult questions of both teams. I hope that gave you I find that difficult questions from the court or from the arbitrator often is exhilarating because that's what we live for, to persuade, to convince the court, to convince the arbitrator, the tribunal, that our side is correct, that our analysis is a good one. And I hope that you've also felt that exhilaration in dealing with my questions, however wrong-minded you might think my questions might have been. On the assumption, as Professor Shi has said, that you're going forward, that this is not the end of your careers in international dispute resolution, I'd just like to make 3 suggestions, things that you might think about going forward. The first is, you have all the time in the world. 15 minutes for each of the 3 issues is quite a lot. So there is no need to speak so quickly. You should slow it down. Your goal is to persuade, to have a conversation with the tribunal or the court. And therefore, you should make sure that the court or tribunal is following you. So slow down. It's not a matter of getting through so many points quickly within the limited time that you have. I would suggest it's a matter of stressing your key, your strongest points, and then dealing with any doubts, concerns, misapprehensions that the tribunal might have. So I would slow things down, and I'd try to make sure, as best you can, whether video or in person, to ensure that the tribunal follows what you say. Second, more and more I find in real life that the question is not so much the law. We can debate various theories of investment treaty law forever and ever, in perpetuity, to borrow the words from Attilus's Testament. But we'll never achieve any resolution over whether Salini is right or wrong. I've read so many accounts on Salini and its critics. I don't think we'll ever reach any conclusion. So you may put out the arguments that Salini has, but I suggest it is far more effective to focus on the facts and how the law, whatever the law may be, applies to those facts. Usually I find in real life, what prevails with a tribunal or with a court is attention to the detail. Detail of the law, of course. You live with the facts. You present the facts to the tribunal. So you are master of those facts. And when the tribunal gives a mistaken idea or misapprehension, you can correct the tribunal. And you should not be afraid to do so. And finally, to echo something that Teresa Cheng was saying, answering questions. It seemed that there was a habit on both sides in dealing with questions from the tribunal, sometimes in dealing with my questions, to speak even more quickly and not really to answer the question, just to say whatever you wanted to say, whatever, not necessarily making clear sense, and then going on with whatever you wanted to say in any event. But that's not advocacy. That's not persuasion. You listen to the question. And very often, as I think you'll find, the questions are there to help you, to give a possible angle that you might explore. Sometimes the angle might be wrong, in which case you can enlighten. You say, thanks for the assistance, the tribunal court, but actually your argument, it doesn't quite hold water for this reason. Frankness, the conversational style, an openness to the tribunal, listening to the question and responding to the question. I think those are the hallmarks of a good advocate. That is what persuades. And that is what leads you, at the end of the day, to prevail in a case. Not just saying whatever to win, but saying things with balance, conceding those points where perhaps you might not be strong, and then persevering on those points where, on your analysis, you're at your best. Thank you very much again for this opportunity to be an arbitrator at this CTAC Frankfurt Moot. And I look forward to, as I say, meeting you in person in the future in some way or the other. Thank you very much.
Thank you, Anselmo. That was very, very nicely said. Much of what I wanted to say has already been said. I'm the last person you're going to hear before you embark on the ceremony and finding out the results. What I have to say is that, of course, you have done the moot today with much skill. And I know that you have put in much work. I, of course, like the others, like my fellow judges, congratulate you on a job very well done. Now, that is half of it. The other half of what you should take away is, how can I improve on what I've just done? Now, I think many of you, most of you who participate, will become lawyers. And within that will somehow become advocates as well. Advocates not necessarily in court, but advocates at meetings when you have to persuade other people, persuade your counterparts, even persuade your clients. So advocacy really does matter. And this is where I think my fellow judges have given you very useful hints for the future, because this will hold you in good stead, whether you become an advocate in court or generally an advocate. Now, it goes without saying that whenever you're going to speak and you're going to advocate, that you need to put in the work. There is no substitute for hard work. As Professor Reyes has just told you, you must be master of the facts. Knowing the law backwards and forwards, as he puts it, is also important. Now these are things which everybody assumes and which you cannot, I think, take a shortcut on. So that where you can then develop your skills is actually as an advocate. Now, what does that mean? To become an advocate in any situation means you want to persuade. That is what an advocate does. And that is, put simply, your job. Now, how do you become a good advocate in persuading your audience, could be a court, to go along with your arguments? The first is to be clear. Clarity is all important. You can have done all the work in the world. You can know everything backwards and forwards. You can be a master of the facts. But if you can't get your points across, then all that effort has been wasted. Now, how do you become clear? Now, much depends on, of course, how much time you have. Professor Reyes has given you actually a golden tip, which even experienced lawyers often forget about, and that is they forget to talk slowly. Talking slowly and calmly is important. Talking slowly has the advantage of enabling the listener to understand what you have to say. Also, talking in a calm way puts the listener at ease, because a good advocate engages with the audience as though it was a chat, as though you were with a good friend chatting over a cup of tea or chatting over a meal. Each of you is relaxed and you are ready to listen to what the other party has to say. Now, so that's one part of it, being clear and being attractive in the way you speak. The second part, which has also gone into, is actually answering questions. It is underestimated quite often just how important it is to answer questions. Now, answering questions gives you a clue as to what the listener wants to hear, or if you're in a court, what the judge wants to hear, what is bothering the judge, and what is standing in the way of the judge or the listener being persuaded by your arguments. That is the point of questions. Nobody asks questions for fun. All the questions asked today were for a purpose, to understand better the case that you are trying to run. So listen to the question and answer it. Now, in answering the question, you do so honestly, by which I mean, if a question can be answered yes or no, you answer it yes or no. You don't start thinking whether it is for you or against you. If you think the question is against you, the natural temptation is to fight against that question. If you do that often enough, you will lose the interest of the listener, because the listener will just think you're just running a series of very bad points. Concede when you have to, but fight when you have to. But be clear when you answer a question. And most important of all, answer the question. Don't try to shove it to one side and answer a different question and hope that the listener has lost interest and will then move on. In a real life situation, the listener will not move on, or worst of all, moves on and is simply not persuaded. Now, in order to be able to answer questions properly, it's not just listening to the question, it is also a matter of preparation. So when you are preparing for a moot, for a court case, for a meeting with shareholders, for a meeting with clients, you anticipate what questions are going to be asked of you. And that is part of the preparation. If you have done all that, and I'm speaking through, I must say, I have not perfected it myself, but this is what I've understood through years of being in the law, like Professor Reyes. By the way, I've had the privilege of working with Professor Reyes in practice, and I've known him for a long time. And he is a person I admire. And when he gives you some tips as to advocacy, you should listen. Now, when you have thought about advocacy, what you have to do, and then you succeed in persuading the listener, or at least you are well prepared, or as well prepared as you can be to persuade, that is, as Professor Reyes says, an exhilarating experience. You do not enjoy the experience if you have not prepared, and if you don't answer questions, and if you are not clear. That is not an exhilarating experience, because 9 times out of 10, you will lose the audience, you will lose the case, you will not persuade. And if you do manage to succeed, it will be more by luck than anything else. And in terms of being a lawyer, you want to try to cut down on reliance on luck. Anyway, I've been far too long, but I do want to congratulate you again, and like my friend Anselmo, would wish one day to meet you all. So thank you very much for inviting me and all the other judges to this moot.
Okay, thank you so much for the party's excellent performance and the tribunal's wonderful and impressive feedback. And I believe the councils have had precious memory, and arbitrators' inspiration and encouragement will be the latter for your future success. And that's all for today's broadcast. And welcome to stay tuned for our latest seminars and award ceremony held at 7 o'clock. Thank you all and see you next year. Bye.
Thank you. Thank you.
复旦大学法学院表示感谢，复旦大学法学院不仅为我们提供了非常实用而且气派的庭审场地，还提供了非常细致的后勤支持。另外呢，特别感谢钻石赞助商北京市环中律师事务所、铂金赞助商金茂律师事务所、金牌赞助商达辉律师事务所、德杰律师事务所、段和段律师事务所、环球律师事务所以及金雀律师事务所。还有联合国贸法会亚太区域中心、香港特别行政区律政司、上海律师协会、绿桥等27家支持机构对本次赛事的大力支持。接下来有请冒众上海分会秘书长江亚宁女士主持致辞环节，有请江秘书长。
尊敬的各位领导女士们、先生们，各位同学，大家晚上好。我是冒众上海分会的焦雅妮，非常高兴，我是受我们本次这个模拟比赛这个的主办方冒众香港分会的委托来主持今天。
悉心准备和无私奉献。在此，我代表冒众向大家表示衷心的感谢。冒众自1956年设立至今，作为我国商事仲裁的国际品牌，近年来不断探索和推动国际投资仲裁的发展。2017年内地赛区预选赛成为内地高校队伍晋级法兰克福国际投资模拟仲裁赛国际赛区的唯一途径。2022年，我们邀请到前世界贸易组织上诉机构主席、北京大学法学院赵宏教授、香港特别行政区高等法院原诉庭高浩文法官和法兰克福国际投资模拟仲裁赛创始人莎宾娜·康纳德博士组成决赛评委团，为各位参与选手带来了国际投资仲裁赛事的饕餮盛宴。决赛和颁奖典礼共吸引了来自10个国家和地区28000余人次观看。从冒众预选赛中脱颖而出的各支高校队伍也在国际赛区取得了优异的成绩。今年，由于赛事规模进一步扩大，赛事赛程首次延续到5日，5天的赛事已于今天下午，也是实际上到晚上才落下帷幕。冒众邀请了法兰克福国际投资模拟仲裁赛创始人莎宾娜·康拉德博士、前香港特别行政区终审法院首席法官马道立资深大律师、新加坡国际商事法庭法官瑞安摩教授、中国人民大学 石进霞教授和前香港特别行政区律政司司长郑若骅资深大律师组成决赛大评审团，这也是首次冒众将决赛评审团人数增至5人。这个好像跟平时的这个我们的仲裁庭还不太一样，但是在国际上确实是有5人，还有更多的这种仲裁庭的组成，拉近参赛队伍与更多知名国际投资法和国际仲裁领域人士的距离，让每一位参赛队员更好地体验国际投资仲裁的魅力。刚才我要跟各位应该讲领队还有相关的评委这个交流的相关我们组织赛事的想法，实质上你们也能感受到冒众在培养我们投资仲裁的后备人才方面，确确实实在尽我们最大的努力，尽可能的给我们的青年学子更多的锻炼的机会。回顾过去1年，面对百年变局，作为全球最受欢迎的5大仲裁机构之一，冒众坚持推动国际一流仲裁机构高水平发展，为我国建设成为国际仲裁新目的地做出自己独特贡献。2022年，冒众共受理案件4086件，其中涉外案件642件，双方均为境外当事人的案件83件，这就是我们说的是纯国际性案件，没有中国因素的案件。法治不断加强涉外法治专业人才培养。冒众作为我国最早设立的涉外仲裁机构，一直以来高度重视人才培养工作。1年1度的冒众杯赛事已成为全国乃至全球最受欢迎的模拟仲裁赛事之一。这个就是我们的跟维也纳威斯杯对接的普通的国际商事仲裁辩论赛。各国学生通过这一赛事增进了相互了解，树立世界眼光，激发创新灵感，确立远大志向，进而积极投身仲裁事业的未来发展之中。根据司法部、教育部等多部委和贸促会关于做好涉外人才培养项目实施工作的通知精神，冒众积极与各大高校、法学院联络并建立合作关系，目前已与北京大学、香港大学、复旦大学等30多所高校签订了合作协议，在互访互通、师资共享、实践基地等方面积极合作，共同探索联合培养高层次涉外仲裁后备人才的新机制。已有不少同学通过以上的合作项目，在冒众，包括在我们冒众上海峰会实习，聆听冒众实务导师的授课，并由此燃起了投身仲裁事业的热情。这个冒众杯，包括这个投资杯，以及在冒众的相关的一些实习，应该讲是很多的学生选择把仲裁作为未来的职业发展，这个应该讲也是冒众在这方面呢给大家学生做出的贡献。2021年，为强化冒众预散赛参赛选手对相关领域知识的理解与实务运用技能，冒众立设的即仲裁课程教学、仲裁人才培养、仲裁科学研究、仲裁为了丰富参赛队的参赛体验，拓展实践与理论交融的更多可能，冒众还专门为本次颁奖典礼安排了主题为投资者、东道国争端解决和国际商事仲裁的发展和未来专业研讨环节。特邀来自复旦大学、环中律师事务所、上海市经贸律师事务所、环球律师事务所和达辉律师事务所的投资仲裁领域专家，就中国双边投资协定项下的投资争端、中国企业海外投资的风险控制等热点话题给出专业意见与观察。最后，我代表冒众感谢赛事的全体赞助商和支持机构， 感谢每一位仲裁员、教练和参赛队员的辛劳付出，也期待在2个小时后同你们分享获得荣誉的喜悦，也期待着从中国内地赛区进入国际赛的队伍能够取得更加喜人的佳绩。谢谢大家。
好，谢谢那个陈杰副主任。通过陈杰副主任刚才的对这个法兰克福国际投资模拟仲裁厅这个引入这个国内这个赛事的这一个简要的介绍，大家可能能够感受到贸仲在培养这个投资仲裁甚至于仲裁后备力量做出的各种努力。我其实从学校毕业已经有将近30年了，其实我对今天的学生应该说，看到有这样的一个比赛，我感觉是特别羡慕的，因为在30年前，那时候我们要去了解点涉外的知识、渠道等等都是非常有限的，而今天可能因为有贸仲以及其他很多相关的机构，包括现在的大学这个一个开拓的视野，其实给大家提供了一个非常好的平台，所以这样的比赛能有更多的人能够投身。我们接下来一位致辞的是。
仲裁这个同学们所经历的体验相关，你们觉得仲裁的准备这种仲裁的辩论跟其他的纠纷解决，比如说诉讼的方式有什么不一样？我和法律圈外的同仁们解释这个仲裁，简单的说就是你找一个你认识的人来解决你的纠纷。诉讼就是你要去找一个或者一些你不认识的人来解决这个纠纷，对吧？如果这个法官是我和季诺这样的关系，那就麻烦了，这个就会被另一方当事人申请回避了，对吧？但仲裁是可以的。那么与这个相关的仲裁的机构、仲裁的机制、仲裁的流程、仲裁的特色，与我们今天所参与的模拟的仲裁庭的准备各位的这个竞争的过程，这个与其他的模拟庭辩论赛相比有什么不一样？第一个问题。第二个主题词呢是模拟庭。这个世界刚刚基诺律师讲到了非常具有危机感有点沉重感的一种局面。更悲观一点说，在ChatGPT AI 这种技术运用大规模杀伤性武器毁灭人类之前我们作为法律人能够做什么，以及各位年轻的学子们还在学校里的时候，我们需要学什么？很多知识性的、信息性的内容已经不再重要，你只要有一个手机就可以解决所有的问题。我们下午在交流的时候，讲到人机接口脑机接口的前景的时候，我们的未来我们需要的法律技能是什么？可能更多的是要通过像模拟庭这样子的方式来训练我们的动手能力、我们的实践能力、我们的操作能力。所以我带给大家的问题是，你们在法学院各位同学准备通过这一次的历练之后你们准备如何的规划你们后续的法律学习？最后一个关键词是复旦。我的问题是，复旦值得你们留恋吗？复旦的法学教育呢，开始于这个大学建立的时候，1905年，在我们的院徽上，1914年是这个大学开始成建制的招收法科学生的年份。1929年正式建院，1983年恢复建系在最新的 QS 排名当中复旦大学法学学科是在全球排名第76位。所有的这些包括你们这些天来所经历的，包括各位嘉宾今天下午所体验到的，复旦和法学院是不是会值得你们留恋，以各种的方式加入或者支持复旦法律学科的发展？最后再次感谢我们茂众对复旦的支持，也希望复旦能够值得大家留恋。谢谢大家。
好，谢谢王院长。我想，刚才我一开始就说了，其实是大家在离开这个竞赛的战场之前，我们来自各方面给大家有一些嘱咐或者嘱托。应该说，我刚才听了，我感觉是沉甸甸的一份嘱托吧。既有我们仲裁机构的，也有我们这个学校的，有我们政府部门的，也有我们实务的律师行业的。大家的这个致辞，我觉得内容还是非常丰富的，既让大家回顾了历史，也让大家看到了未来的一个发展，也对大家未来的 发展有一个相应的指引。非常感谢四位的支持。根据这个会议的安排，我们接下来要进行合影，是吧？邀请各位刚才致辞的嘉宾以及今天随后将要进入研讨环节的各位嘉宾到台上合影留念。谢谢。
谢谢各位嘉宾的精彩的致辞。接下来呢，我们进入今天主旨演讲的环节。我们今天很有幸的邀请到了茂仲仲裁员、新加坡国际上诉法庭瑞安谋教授，做题为“调解解决投资者东道国争议的困境和出路”。相信刚刚大家也已经看到那个瑞安谋教授的一个非常犀利的点评，还有一些比较犀利的问题。所以呢，我们接下来就有请他。Today, we are very honored to have Professor Anselmo Reyes as our keynote speaker, who will be focusing on the use of mediation to resolve investor-state disputes, likely difficulties, and possible solution. Professor Reyes is currently a judge of the Singapore International Commercial Court and also a CTAC arbitrator. He was appointed as a judge of the Court of First Instance in Hong Kong and served in that capacity from 2003 to 2012. As a judge, his specialization was construction, arbitration, commercial, and equity matters. He obtained a BA in law, LLM, and PhD in law from the Cambridge University. He was appointed senior counsel in Hong Kong in 2001. The floor is yours, Professor. 欢迎。
Thank you very much. Secretary General of CTAC, Mr. Wang Chengjie. President of the Shanghai Bar Association, Mr. Ji Nuo, distinguished representatives of Fudan University, ladies and gentlemen. First, like the Secretary for Justice, may I begin by congratulating all those who have participated in the moot over the last few days. As I said earlier today in judging the last stage of the moot, I hope that this experience will spur you to continue in international dispute resolution. I'd also like to thank the organizers, CTAC especially, for inviting me to deliver this brief keynote speech. I've been asked to deliver a brief keynote speech over 10 minutes, and I've chosen the topic of international investor-state mediation. Within the short time available to me, I think the best I can do is to lay a challenge. The panel discussion that follows this keynote speech will be a panel discussion on investor-state dispute settlement and international commercial arbitration at a crossroads. So we are at a crossroads of investor-state dispute settlement. What I'd like to suggest is investor-state mediation a better way of resolving investor-state disputes than international arbitration, investment treaty arbitration? The problem with arbitration is it is adversarial. It is not, like mediation, a matter of finding common interests and trying to see how both to investor-state mediation, a different dynamic from mediation in international commercial disputes. Imagine yourself as a mediator in a dispute between an investor and a state. Let us say that you are a very skillful mediator, and after a while, you come up with an excellent deal, one that is hugely satisfying to the investor and hugely satisfying to the state. You've been able to understand, analyze, explore their common corresponding interests, and you've come up with some sort of arrangement through your mediation that everyone likes. What's the problem then? The problem is in the state, because quite often there will be critics of the state, critics of the government of the state, and the state has to look to the future. Very often, if a state does a deal, no matter how good it is for the state, the opposition, the critics will be saying, the state has sold out. It's done a deal too cheaply. It could have held out for more. It could have done much more. Quite often, you will have to get the buy-in, the agreement of different departments, ministries within the particular state. And one ministry may be reluctant to agree unless the other ministries also agree, because if the ministry agrees and the others don't, or in the future, if the deal goes ahead and someone finds something wrong, then the ministry that agreed first will be on the firing line. So the bureaucracy is such that the ministries will be reluctant to be the first one to okay the plan. And therefore, there may be problems in getting the deal, however good it is for the state, to go ahead. The state may feel it's far better to have a solution, a determination by an arbitral tribunal, possibly by a court, so that I can say, the state can say, that I was forced to do this. I was compelled to do this. I argued as best as I can at the arbitration, at the court proceedings, if you go to court, but at the end of the day, the arbitrator, the tribunal, found against me for these reasons. So I have to comply with the finding of the tribunal. At that moment, the state can say, I did my best. I didn't sell out. And no one, and it would be difficult to blame anyone for that. So I've seen in my discussions on investor-state mediation with various stakeholders that there's a great difficulty. There's an inertia in trying to adopt a mediated settlement, no matter how good it is. So that's the problem. That's the dynamic that you have in investor-state mediation that I don't think you have in international commercial mediation, where the two commercial entities that are disputing with each other can come to a commercial decision. So if that's the problem, I've said I'm going to go into possible solutions. What are the possible solutions? I've thought long and hard about this, and I'm afraid I have difficulty seeing a possible solution, and that's the challenge I'd like to throw to the panel discussion that succeeds my keynote speech. Investor-state dispute settlement at a crossroads. How can we make investor-state mediation something that is effective, something that works, something that states will not be hesitant about buying into when a good deal comes along? How can we do it? Let me offer a tentative possibility and then identify possibly two problems, at least two problems, with my tentative proposal. If you need to get the buy-in of a number of stakeholders within the government, if you need to get a buy-in amongst critics or opposition within a government, then it seems to me that the mediator will have to engage in a much wider mediation exploration than simply with one representative of the state. The mediator may have to communicate, meet in caucus, meet confidentially perhaps, with various potential stakeholders, other ministries that would have a say on whether the government goes ahead on the matter, possibly critics of the government, have to go at some point. And what point? Sooner rather than later, that will be at the mediator's discretion, the mediator's decision, depending on the particular circumstances. But if you just focus on one government entity to try to come to a solution, then you may encounter, you probably will encounter, the difficulty that I've just sketched out. Now I said, why am I reluctant about this solution? I see at least two problems with it. One, I said that it's the mediator's discretion when to broaden the stakeholders that the mediator consults in coming to or in fashioning a settlement agreement. When precisely? Especially to maintain confidentiality, because if word of these potential agreements leak out, then there will be critics that will pounce on the rumors and say, this is not a good deal, this is a bad deal. That will spoil the atmosphere of the mediation, of the negotiation. The more people that you consult, the more likely there will be rumors, there will be leaks, there will be problems with confidentiality. That's one problem. The second problem I foresee is in a recent publication, I've suggested that arbitration is not an ideal way of dealing with a dispute that involves more than two parties. It is perhaps a great way of resolving disputes between the two parties that are privy to an arbitration agreement. But once you have third parties involved, or in the example I've been given, other stakeholders involved, then you have a multi-party situation. And arbitration doesn't cater for that. Mediation can. But we are not well developed in our techniques of multi-party mediation, where there are many moving parts, and you have to get the buy-in, the agreement, of quite a number of stakeholders, especially within a government, within a state. We have to develop, if this is to go forward, if my solution is to have any chance, we have to develop more sophisticated techniques of multi-party mediations, how to achieve settlement or resolution through mediation discussions, through caucuses, amongst multiple stakeholders, not all of whom you would be consulting at the same time. These techniques have yet to be developed, and another challenge I would pose, or a sub-challenge that I would pose to the panel discussion, is how can we develop these techniques? How can we develop investor-state mediation? So I hope I've given some food for thought for you. I hope I've given some meat for discussion in the panel discussion. It seems to have quite a lot of interesting topics relating not just to mediation, but to arbitration. I hope that we can, in the future, develop techniques of investor-state mediation to overcome the inertia, the difficulty, the problems that I've identified. But much of that will depend on you. Much of the challenge will depend on you, the young generation that is looking to resolve disputes on the international stage. And I look forward to hearing how you propose to tackle these difficulties. Thank you very much for inviting me to give these few words. As I say, I regret that I'm not able to be with you in person, but I hope in the near future I can be in Shanghai and I can resume my travels to Shanghai and meet as many of you as possible in person. Thank you very much.
Thank you. Thank you, Professor Reyes, for your sharing and also setting up a really good tone for our panel discussion later on. I hope that our panelists later on can really provide us with some of their personal perspective or some proposals for addressing the topic. And now we are moving on to our panel discussion. 研讨环节将由行源律师担任主持和评论人。行源律师是北京市环中律师事务所合伙人，对外经贸大学法学硕士，中国国际投资仲裁常驻论坛副秘书长，主要的职业领域为国际贸易法、外商投资法、公司法、特许经营法。自从业以来，处理了大量这些领域内的争议案件，其中包括在贸仲、在国际商会仲裁院、香港国际仲裁中心、亚洲国际仲裁中心等各大仲裁中心的仲裁案件，以及在国内法院具有重大影响的涉外经济类诉讼案件，具有丰富的争议解决经验。现在有请行源律师。
各位领导，各位在线的还现场的业界同仁，各位老师、同学们、女士们、先生们，大家晚上好。那么我非常荣幸呢，能够主持本次的研讨环节。本次研讨的主题是投资者东道国争端解决和国际商事仲裁的发展和未来。那么在这个题目当中呢，我们可以看到，其实它提到了2种仲裁。一个是国际商事仲裁，一个是国际投资仲裁。尽管呢都是仲裁，但是实际上两者还是有很大的区别的。国际商事仲裁呢，它主要是平等主体之间的解决纠纷的一种方式，它是保密的，它的这个解决纠纷的基础是双方之间签署的仲裁协议，案件的这个裁决呢也是不公开的。这个国际投资仲裁呢，它不同了，它有很强的公法性质，它解决争议的基础呢是国与国之间签署的投资保护协定。国际投资仲裁的裁决呢，也有大量的是公开的，因为它涉及到了很多的公共政策，还有公共利益的问题。那么这些裁决呢，也在一定程度上起到了造法的作用。相比之下呢，国际投资仲裁对于从业者的要求其实是非常高的，不仅要有很强的语言能力，要有很强的国际视野，还要有极强的研究能力，不仅要对国内法非常了解，对仲裁程序非常了解，还要精通国际法，包括国际经济法、国际司法、国际公法等等各个领域。所以呢，这个对人才的培养其实就是非常重要的，尤其是在“一带一路”倡议实施以后，以及呢中国企业走出去，越来越多企业走出去，越来越需要利用投资仲裁这样的一个工具来保护自己的权益的情况下，那么我们国家对于这个人才的需求就是越来越迫切了。所以呢，我要说的是，我们贸仲举办的这个比赛，还有研讨会等等的这些活动，对于我们国家相关人才的培养都是非常有重大的意义的。那么今天我们研讨会呢，请到了4位非常专业的国际商事仲裁、国际投资仲裁领域的专家。我给大家介绍一下，这位是经贸律师事务所合伙人韩正律师，这位是复旦大学的副教授梁勇女士，环球律师事务所合伙人张欣先生，还有达辉律师事务所合伙人马志华先生。好，马律师呢，因为是不能到现场，所以他就今天就是在线参加。好的，那我们首先就有请韩正先生
来发表他的演讲。那么韩正先生演讲的题目是“仲裁作为中国企业海外投资控制风险的手段，理想或现实”。欢迎。
好的，谢谢各位。
首先我稍微提醒一下，我们因为时间限制，建议是在13分钟左右，我会在10分钟左右的时候提醒您一下。
好的，PPT 能放一下吗？好的，那我站起来了。好，我向这个主持人之前保证过10分钟之内来解决。因为投资仲裁这个题目呢，今天在座的各位领导、专家学者，还有我们今天参与的同学，实际上已经学习了很多。那么，所以呢，我是从法律职业角度为这个题目拉开一些序幕大家看一看，就这2年有哪些值得我们关注的热点。那么这样呢，来有一个从职业角度的认识。那么理论知识，大家有很多的机会可以学习。那么实际上呢，中国企业以投资仲裁为工具保护自己已经是现实过去曾经可能是理想。我们看到的统计数据是，截至2021年的时候呢，中国投资者提起的投资仲裁呢，总共能够查到的记录只有18件，数量相当少。但是呢，从2022年至今这差不多1年半时间，已经有5起仲裁案件提起，都是由中国这个企业提起的。那么右边呢，可能不一定看得清右边呢是这个大家上 Exit 的官网就可以看到这个数据，它的这个数据呢只披露了一些基本信息，我们也做了一些侧面了解。那么不光在数量上有增长，同时呢，这个有一些领域已经是新领域的问题了。像第一个案件，这个案件呢是涉及在特立尼达多巴哥中方投资的一个炼铝厂，这个呢属于一个传统的基础设施基建类的项目。那么第2个和第4个案件呢，这都是中国电建集团和中铁18局集团在越南投资的海上风电场，是新能源项目。那么其中第3个呢 ，PCCW 呢是香港的这个盈通电子，是当地最大的通信企业。那么它的子公司在沙特所投资的项目，这个投资项目是当地的通信业务。随后呢，因为这个通信许可证被取消掉了。那当然当中有一些可以理解的地缘政治因素，这个我们不去详述。那么这也是很有意思的一个案件。那么最后一个案件是2022年的这个案件，是众所周知的华为诉瑞典政府的5G 协议的索赔案件。所以我们看到，在这样一系列案件发展当中，不仅有新类型的项目，同时呢，这个中国企业在一些关键的领域都拿起了这个武器来保护自己。那么我们当然可能大家在接触投资仲裁之前，都会认为说投资仲裁是一样高深莫测的东西。但是实际上呢，只有当我们越来越多的企业把它从一个特殊武器变成一个常规武器，乃至变成一个常规工具，政府官员了解投资仲裁，企业经营者了解投资仲裁，公司法务了解投资仲裁，一般的律师也了解一些投资仲裁。当做到这个的时候，我们就可以说，投资仲裁已经成为在国际经济交往当中中国企业常用的一项工具。那这个是我们大家需要进行的努力和要实现的这个目标。那么我们来看一下近年来的一些投资方向和热点。那么左边一列呢，实际上是偏传统的“一带一路”的基建和能源建设的投资，这个也是此前中国投资比较多的。那么在这当中呢，有哪些问题可以注意呢？一类呢，就是我们“一带一路”穿过的许多国家，相对来说呢，它可能并不属于发达国家。我们举的第一个案例是这个 Metaltech 是乌兹别克斯坦的。那么这个案子呢，是以缺乏管辖权驳回来，就这个 BIT 当中没有这个同意仲裁的条款，直接驳掉。那么像乌兹别克斯坦这样的中亚国家还不止这样一个。底下一个这个就潘维尔诉哈萨克斯坦这个案件呢，它有个表面上的这个仲裁条款，然后呢接受了案件。接下来哈萨克斯坦做了一件什么事情呢？他在这件事情之后修改了他的 BIT 协议，把那个拿掉了。所以呢，我们就会意识到，在整个“一带一路”上，大家对于可能提交国际的投资仲裁的保护他们曾经与我们一样，同样 怀有某种对未知事物的恐惧。那么整个由某种主流传统所形塑出来的机制，他们也不熟悉，他们也恐惧。那么当我们学习了、掌握了之后，那当然我们要把它当做一个公共产品，而不是进行这个私权声索的一种工具。那这样呢，才能够使得这项工具成为大家普遍接受，我们也能从中得益，别人也能从中得益的工具。那么第二类呢，涉及到能源问题呢，大家可能如果稍有了解的话呢，也会知道这个能源宪章，欧洲能源宪章现在已经进入落幕时刻，有可能退出历史舞台，是否能够把它盘活不知道。那么这里举的第一个案例呢，这一家这个油气开发公司呢，就是在意大利修订了这个油气勘探保护范围它禁止在12海里范围内勘探新的油气资源，然后呢导致了本案的索赔。那么像意大利、德国、西班牙多个欧洲国家都已经明确表示退出 ECT。那么所以呢，在目前的这个国际环境和国际能源的情势下，未来的能源投资实际上面临很大的不确定性。而底下举的两个案例呢，一个诉厄瓜多尔的案件，是厄瓜多尔政府呢对这个自然资源公司苛收了一个叫暴利税的东西引起的争议。再下一个案件呢，是与这个导致的环境海洋污染有关的投资仲裁案件。那么在目前新一批国际的这个 BIT 的探讨和签订过程当中，我们就会注意到很多国家都在把环保、把绿色、可持续因素呢加到投资保护条款当中，形成某种对投资者的限制或者是约束。那这个呢，可能是未来值得重视的。包括像目前退出 ECT 的这些欧洲国家，他们主张的理由甚至也是说因为与巴黎协定不符。那实际上是不是真的这个理由，这个是值得探讨和研究的。那么右边这一类呢，实际上也是目前斗争非常敏感也很激烈的领域，就是高科技的并购和投资领域。那么目前呢，这个开始增多高发的一类就是股东直接主张反射性损失，像我们本年的赛题当中也稍微提到了这个概念。那么在传统当中呢，这个会来提起投资仲裁的这个主体相对有限，但是呢，随着新一代的这个 BIT 的增加，我们看到像很多在2012年之后美国修订的 BIT 范本当中，它能列为投资的甚至有10几个类目，范围越来越大，越来越广。那么如果再加上对其持有股权的股东的反射性索赔，这个范围有可能会不断增大。所以像这个案件是一个比特币投资投资之后呢，因为加拿大当局的管控导致公司损失好，几个股东跑出来索赔了，最后也支持了。好，那么当中一个案例呢是国家安全介入，这个是目前也比较有争议的一个问题。国家安全的边界在哪里？究竟有没有这个公开可测度的方式来评价国家安全？那这个案例当中呢，津巴布韦呢是以国家安全的理由征收了这个声索人的3处资产，最后被仲裁庭认定要承担责任。那么也就是说，在国家安全它并不免受投资中医仲裁庭的审查，就是它虽然你可以作为例外，但是我仲裁庭仍然会来审查这个问题。那么最后第3个问题是经济制裁包括执行制裁和反执行制裁所可能引起的潜在的投资争议，但是这个话题过于庞大，我们今天就不考虑了。好，那么接下来呢，最后呢，我们整理了一个简单的境外投资风险的管控的工具箱。第一个就是当地尽职调查。为什么提当地尽职调查呢？在许多份这个仲裁裁决当中，仲裁庭明确指出，就是说，如果你是尤其是主张当地立法变化导致的损失，你必须有一个合理的预期，或者说合法预期。合法预期什么能够证明呢？如果你对当地的法规、当地的合规立法有一份当地的尽调报告，我就认为你满足标准了。那么这个就是在投资仲裁裁决造法的一个典型体现。那么像这类呢，实际上就给了许多投资者一个机会，我可以提前购买这个尽调保险。这个尽调买到手之后，以后你如果出现法令变更，我可以主张我在投资当时，在你法令变更之前，我是有合理预期的。 那么第二个呢是这个投资及运营部门要保留相应的项目合同文档、风险报告并阅读。这个工具是前2天杨良一老师提供给我的。他说他发现很多企业直到纠纷发生了才开始去找合同在哪里，在履行过程当中，在项目运行过程当中都没有人阅读过这个合同只有当时签合同审核的人知道合同里面签了什么。运营部门、财务部门还有这个负责的这个管理部门都不知道合同上面写了什么，也不知道项目文件有哪些具体内容那么其他的几项内容呢，这个我们就不一一去介绍了时间是不是差不多？
您的这个时间管控非常的精准。
好的，那谢谢各位。
正好是10分钟。谢谢韩律师，谢谢。那么韩律师的这个讲解呢，正好给我们体现了一个非常专业的从事国际投资仲裁的一个实务律师的样本。那么在学术上对非常前沿的问题也是很了解的，研究的非常的深，而且能够深入浅出的给大家讲出来。另外呢，就是在这个实务上还有管控工具箱这样的非常具有借鉴意义的这样的建议，那么我相信对企业也好，对于我们从事这个职业的专业人士也好，以及将来要从事的人士也好，这些都是非常有意义的。另外一个我听到比较有感触的一点就是韩老师提到的这个国家安全也并不免受审查，就是这些非常前沿的以及非常可能会超出我们原来的一种想当然的一种东西。这个呢就提醒我们在国际投资仲裁当中呢，大家是要保持学习的，因为它总是会有很多很新的问题，包括我们在这次赛题当中遇到这个人权问题。那么人权问题呢，它在2016年的一个案件当中，我们发现它也可以在投资仲裁当中进行管辖。那所以呢，这就要求我们要不断的进行学习，不断更新自己的知识库。我就先说这些，谢谢，再次感谢韩律师。好的，那我们下一位发言的嘉宾是梁勇教授。梁勇教授在复旦大学法学院获得法学学士学位、法学硕士学位和法学博士学位，随后成为复旦大学法学院的法律系教师、赖布富布莱特学者和耶鲁福克斯研究员。他在中国学术研究领域有显著成就，在中国对外投资领域发表了4部专著和40多篇论文，并获得了多项著名的奖项。有请梁教授。
谢谢各位同仁、各位未来的我们的这些优秀的学者和实践者，好吧？我今天很高兴跟大家分享这么一个之前的一些研究的一些内容，然后呢，也希望获得大家的一个共鸣。那么关于这一块问题呢，是我的一个命题作文，那么我跟大家所展示一下。那么大家都可以了解，就是中国有一个庞大的双向投资的一个规模，然后呢，这些规模呢累积了大量的投资风险。双向的投资风险，那么这些呢是从世界投资报告当中直接截取出来，可以看到中国的长期来讲，近年来一直是属于海外投资的处于第2位的流量，然后在吸收海外投资当中呢，因为我们长期处于仅次于美国的一个发展中国家当中的首位，对吧？在所有国家当中第2、第3。当然，这一张表呢，就是说从中国的对外投资直接统计公报里面所展示出来，从2002年我们第一次说走出去，到2021年这20年当中，我们每年的投资的流量的这样的一个发展，这一张呢是投资存量的一个发展，可以看得到的这样整体的一个规模效应。那么同时呢，刚刚就是韩律师讲的这个问题呢，恰恰我也可以做一些回应或做一些补充。其实我们希望所走的这样的一个投资仲裁机制，尽管有大量的这些内容或者从实践也好、理论也好，说有大量存在的一些问题，但是呢，我们觉得它好用，确实有效果。但是我们回到视野，回到中国的话，我们是一个什么样的一个状态呢？我刚说了。风险呢，大量的双向投资呢，规模很大，风险不断累积。 但是我们现在的这些 BIT 是不是足以保障我们的这些海外投资，或者说是这样的这些 BIT 对如果未来其他的外国投资者用来诉中华人民共和国政府的时候，我们是不是可以足够的自己的一个保障？所以我想今天是从这是说涉华的案例的一些风险点来说，给大家做一个展示。那么这张图呢展示了整个过去的应该不是20年，应该是41年。整个中国的对外签署的 BIT 的发展，那么这里面呢，我没有特意区分开来，它的重新的 renew 的就是更新合同的情况，一共是145项，按照就是 ACTA 的这样的统计。那么从这张表上，大家应该可以非清晰的展现出来，整体的我们的投资的峰值，就是协定的签署的峰值是出现在上个世纪的90年代和本世纪的初。那么除此之外，当然我们还用大量的自贸协定在补充。那么这个数据要更新，因为就在昨天，中国跟厄瓜多尔又签署了自贸协定。现在我们的自贸协定已经涉及到了27个国家和地区。那么今后我们可能会更多以自贸协定的方式来走。那么整体来说，从我们统计公报说，我们在190个国家和地区有投资。我们呢也签了，把这些重叠的 renew 的这些东西更迭掉呢，一共是132项 BIT 和涉及到现在是应该是20项 FTA 当中涉及27个国家。那有没有把它整个都覆盖住呢？感觉整体来说呢，覆盖了70%，实际效果呢并不是这个样子的。因为效果当中的最大的一个问题，因为我删掉了一些 PPT， 我觉得这个是内容太长了。因为第一个问题就是我们的很多海外投资的流向的大国，比如说美国，比如说就是一些重要的国家，美国我们没有签，对吧？欧盟我们也没有认地域国家和地区。那么印度、印尼、厄瓜多尔，实际上它都单方面的已经废止了 BIT 了。那么第二个就是说，我们的这些 BIT 老旧意味着。实际上，对很多新问题，就像刚刚韩律师提出的很多新问题，比如说气候变化、国家安全，包括我们的争端解决机制，是不是能够适应到绝大部分的争端解决，还是仅仅限制在以征收和国有化引发的补偿额争端？这个都值得我们去进一步的这样的一个思考。那么正好就是不约而同，我们是英雄所见略同嘛。我也做了一张表，就是说关于中国的作为的涉华案子当中，就是因为我这统计到就是 ACTA 的这样的一个统计，把23年的这一块内容没有放进去。那么整体来说，从中国作为被诉国的情况呢，2020年3起，2021年2起，最近呢好像没有。然后呢，作为申诉国呢，因为我正好少那一个案子，2023年的这个案子，正好韩老师我们韩律师正好一个互相的一个补充，可以看得出，2020年2起，2021年4起，2022年4起，那么整个速度是在加速，证明我们的投资者也越来越，当然规模增大，投资者也越来越注意到用这样的一种方式，这是一种很好的工具箱的中心有用工具来进行解决这些问题。那么当中提出来的一系列的这些案子给这些 BIT， 可以看到绝大部分的 BIT 涉诉的 BIT 都是在上个世纪所签署的这样的一个情况。那么我总结了大概有一些问题，当然这个问题的 list 是没有终止的。第一个就是说，港澳的投资者他究竟能不能适用 BIT， 就是能不能适用中国对外签署的 BIT。那么这里面有好几个案子，对吧？就是说谢业生诉秘鲁的案子，世能公司诉老挝的这个案子，其实这里面都有。就是说我香港的自然人，或者是在澳门投资的企业，我再到第三国去进行投资，或者第三地去投资的时候，我究竟能不能用中国对外签的这个 BIT 来进行保护？因为毕竟香港是一个重要的我们进行税务筹划的时候做一个重要的一个中间地。那么从现在有趣的地方呢是这样的，我直接 move 到这样一个结论。这个结论呢，从实践当中很有趣。 就是所有现在涉诉的 BIT 呢，都是中国恢复对香港，我们中华人民共和国中央人民政府恢复对香港特别行政区和澳门特别行政区行使主权之前的这些事情发生的。第二个呢，我们东道国都反对使用 BIT， 然后呢，中国的外交部门呢，其实也表达了支持东道国的这个态度。然而，仲裁庭支持了投资者。那么这个问题对于我们国家来讲比较突出的，其实源于什么呢？一国两制。因为我们的一国两制决定了它的基本法、宪法和基本法都规定，这些中华人民共和国对外中央人民政府对外签署的这些协定，经济方面的、贸易方面的，它不主动自动的适用到香港和澳门。那么它需要根据它当地的情况，并征求它的一个意见。那么这个问题就相当于对我们来讲，处于一种相对来说极其不稳定的一个状态。那么有例外，研究下来，2006年的中国和俄罗斯的 BIT 是一个例外。这个例外当中，它明确说清楚是排除香港，只限制在中国内地，不包括中国香港、澳门这样的一个问题。那么好像也没有延续。有没有这问题我之前专门咨询过外交部、商务部的很多这个老师，说这个问题很敏感。如果你说一直排除也不合适，一直说不说，可能目前来讲是一个在政治当中或者是在商务当中一个比较现实的一种考虑。第二个就是国有企业，它究竟能不能作为一个合格的投资者来进行诉讼？不叫诉讼，就是把这个争议提起来，对吧？那么这个问题在我们的2014年北京城建诉也门案当中已经发生了。也门政府提出的5个点当中，其中有一个点就是说，因为你北京城建是家国有企业，你就不能没有这个权利，你就是一个国家的代理人。对吧？你在行使国家的这样的一个职能，尽管在管辖权决定当中最后没有得到这个支持，但这个案子最后是和解了。那么管辖权决定当中，最后仲裁庭是认为，他没有去基于 Bruch's Test 的这样的一个测试，他认为，他既不是国家的机构，也不是国家的代行他的相关的职责，所以呢，支持了这样的一个主张。那么刚刚韩律师显示出来的这些 case 里面，那么多的企业，其实很多都是国有企业。那么国有企业未来它会不会被争议，会不会被 challenge 这样的一种可能适格性，这个我相信未来还是会要去提，未来可能还会提，因为有一点，我们今天的国有企业和1972年 Bruch's Test 提出来的国有企业的概念已经不一样了。国有企业的概念也在动态的发展。好，第三个就是这个问题呢，可能随之 BIT 的更新可能会带来的一个问题，新旧 BIT 更迭期间的过渡期间，它的一个适用问题。最典型的就是我们国家提起的第一案，就是平安诉比利时政府的这个案子当中就提及了这个问题。那么这一点，我相信我们的法务和律师，以及包括未来的这些我们的法律从业者的一个未来是很重要的，就是信不要乱写，对吧？我就想这个信乱写，就是说你这个信里面，尤其是第2封信，你说我写封信通知他发生争议了，这是一种传统的我们国内法上的一种概念，什么呢？诉讼时效的中断，然后我发你通知，发你一个对账单。实际上他说，我们现在有个通知，这个发生的争议是1984年下的 BIT， 那你这个后面不是一个反言的样的一个问题吗？对吧？这是我们的律师可以做的事情，告诉他信乱写，那不行，你得购买我的服务。好，那么当然就是说，还有一点我们可以看到，我们国家自己也没有想非常很清楚。就是你比如说05年当中签的4个协议，你看它的过渡期的要求，对以往发生的争端，在就是说新协定生效之前发生的争端到底怎么适用，规定都是不一样的，对吧？有些这些还都是跟欧洲国家签的，那只能说他可能还没有完全想好，或者在不同的谈判组里面，他可能有不同的想法。第4个就是 各位肯定耳熟能详的，就是最惠国待遇原则的它的一个适用问题，对吧？这一点呢，我就想比较越过去了，对吧？最惠国待遇原则对我们国家最大的风险就是我们有3代 BIT。刚刚韩律师讲到的那个中国中国各位提到乌兹别克斯坦，然后我就想到乌兹别克斯坦正好是中国乌兹别克斯坦第一个好像是明确把最惠国待遇排除适用争端解决机构的这样的一个模式，对吧？好，那么我好像一直在回应韩律师的这个问题，就是说这个
12分钟了。
OK， 好，正好可以讲完。就是我们的国家安全的这个相关的条款，华为案他讲的这个问题当中，我对这块有所关注，也有所了解，因为这一块的问题是一个大的一个坑，将来有一个极大的一个不确定性。但是我相信各个国家可能在非传统安全和传统安全交织变异的过程当中，今天我们的国家安全可能从原来的点性国家安全变成网状式的国家安全，点多面宽。整个世界的各个格局当中，它的国家安全可能要重定义。对中国来讲比较突出的，因为我们还可以把 WTO 当中的4个案子 DS 512、567、544、597，其中有2个案子可以牵连起来，一起来做一个研究。最后呢，对于中国来讲，可能更突出的问题，中国政府背书的案子，绝大部分是跟土地使用权有关系的案子，或者是提前取消，或者是改变这样归属。这个问题呢，我觉得太长了，也不好说。所以呢，这个问题呢，就留待各位的就是我们觉得更优秀的后来者来继续的来挖掘和发展，好吧？谢谢。
谢谢梁教授非常精彩的演讲啊！如果不是时间问题的话，我其实还挺想听梁教授继续再讲一讲的。因为梁教授这种实证的研究啊，对大量的案例、大量数据的分析，最后得出的这样一种结论，是在10几分钟之内呢，给我们浓缩了极多的信息。其实非常有收获，真的非常有收获。印象很深的是梁教授提到这个中国签署的 BIT 是否能够适用到香港、澳门的问题，以及这个国有企业它是否是合格投资者的问题。这些问题其实在中国都是非常现实的问题，尤其这个国有企业，就跟我们咨询的很多的当事人，在境外投资的实际上都是国有企业。这也是因为中国“一带一路”国有企业大量的走出去，它存在大量的投资的风险，所以国有企业的这个能否具有这个合格投资者的身份，对于我们国家来说真的是太重要了。所以梁教授的研究非常有价值和意义，谢谢梁教授，谢谢。那我们请下一位嘉宾张欣博士发言。张欣博士是环球律师事务所合伙人，具有中国律师与英国律师的资格，现担任茂众等多家仲裁机构仲裁员。他参与了3起国际投资仲裁案件的工作，将国际投资仲裁学术研究与实务工作有机地结合起来。所以他今天跟大家分享的是如何从中国律师的角度来多维度的观察与评估国际投资仲裁。有请。
因为我没有准备 PPT， 所以我还是坐着讲，大家听起来也轻松点。刚才这个韩老师和这个梁老师已经给大家分享了，就是中国涉及到投资仲裁的一些数据和案例。从律师的角度呢，我也给大家汇报一下我们目前的一些观察和思考。第一个方面呢，就是中国律师参加国际投资仲裁现在处于一个什么样的状态？任何业务我们都说从0到1，再从1到N分2个阶段。从0到1是最重要的突破。从这个角度来说，中国律师从最早的观察者、学习者，到后面的这个部分的参与者，到现在案件的全部的参与者，可以骄傲地说呢，应该已经突破了0到1这个环节。大家更应该关注的是如何从1到N。那在我们前面是星辰大海，前途光明还是说是前途是光明的，但是道路是曲折的亦或不知道，没法预测上蹿下跳这个局势遇到什么案子大家做什么案子。 如果问一个律师呢，我想可能咱们毫不犹豫就会说，那肯定是第三种情况，因为对于一个律师来说呢，很难对整体进行预测和把握，也无法进行相应的掌控。但这个回答可能太经验主义了，所以我觉得呢，我们还是应该再多深入探讨一下国际投资仲裁有哪些特点啊，了解它的特点，我们再来做相应的一些预测。我个人总结呢，从律师的实务角度看注意是从律师实务角度看，国际投资仲裁有3个特点。第一个，案件发生具有低频性低频率的低频性。第二个，案件的历程，它的处理历程具有长期性。第三个，案件的办理有很强的学术性。为什么说它是具有低频性？国际投资仲裁它首先是仲裁，其次呢，它在很大的程序性的问题上和国际商事仲裁相比差别并不特别大，更准确的说，是和对抗性的国际商事仲裁的程序为基础的。所以说在这个过程中，大家会发现这个之所以说它低频不是说它少有这么多案子了，而是说跟国际商事仲裁相比，它的发生的数量毕竟还是相对较少是从这个角度说的低频。同时呢，在案件的处理过程中，它是个很长的一个历程。这个给大家举个一个相对比较贴切的一个例子。其实呢，如果找一本经典的讲国际仲裁的这个书过来，把它翻开第1章序论跳开，从第2章管辖权开始，基本上一章章的往下找，不说每一章里面所说的手段能用上，但是大概80%-90%都可以在国际投资仲裁的实际的程序处理中能够用上。这导致双方不管是代表东道国还是代表投资者，律师手中有大量的工具箱中有大量的工具，导致这个案件的处理流程特别长，而且提出了一个申请，仲裁庭会很严肃的进行考虑和回应，在考虑决定之前，往往还会给对方1次甚至2次进行评议的一个机会，以至于有时候一个案子提起来之后，大概到了第2年的下半年了，他可能才开始进入决定是不是管辖权要分布管辖权和实体问题要分阶段审理的问题。那这个长期性，可能大家第一个感觉是说，对于律师来说，哎呦，这案子可以打好久能够赚好多律师费，这是第一个感觉。不对，对于律师来说，如果一个案子能够要打好久，第一个感觉是哇，这个很大的一个压力。为啥呢？你一个案子能不能养活这个团队，能不能够把它一直维持下去，能够高强度的投入这个工作，这是一个很现实的问题。第3个特点就是国际投资仲裁非常鲜明的与商事仲裁相比，它的学术性特别强。我们都说这个司法3段论这个法律大前提、事实小前提、结论。正常我们写这个诉讼也罢，商事仲裁也罢，法律部分其实写的不多重点是把事实写清楚，怎么样来适用。但是呢，在投资仲裁中学术性特别强。为什么？因为它具有很多的文献。刚才2位这个律师，包括主持人也提到，大量的案例是公布于众的，尽管不是全部，但是呢，已经足够庞大了。在这基础上，还有很多学术研究的文章。所以说呢，在国际投资仲裁中，大家要准备一个 submission 的时候，会发现法律这个部分要写不少我经常开玩笑说，就像在写论文一样。才有个特点，别看它有这么多案子，最后数一数统计一下，有这样的数据，其实活跃的大概就是20-30位国际上的仲裁员，而且有大量的裁决公布于众。仲裁员的观点，尤其在投资仲裁中形成之后，他不会轻易的左右摇摆因为这也会涉及到大家如何评论他的观点，以及如何选择仲裁员的问题。所以说呢，如何加强对这些主要的主流的，目前还主要是西方的20-30位核心仲裁员的成案的观点的研究，其实是对以后不管是中国投资者去利用这个仲裁作为武器，还是我们代表中国政府应诉，在选择仲裁员阶段非常有作用。而这一点，每一次在有案子的时候，我们再来研究， 其实是非常的仓促。这一点呢，也有待于就是说这个我们的学术机构和仲裁机构的研究院啊，如果能够在这方面能够和律所一块儿形成合力的话，我相信会有很大的帮助。第二个观察呢，就是薄弱点在什么呢？还是要继续加强对国际投资仲裁案例的梳理、总结和积累。贸促会应该是前2年给这个5大牵头的各大高校都有参与啊，有一个国际投资法案例的一个叫做摘录汇编吧，这个其实是做了一个非常好的一个基础的工作现在我看已经公告出来了大概150-160个案例了158个，得问一下齐同齐教授，这个到底后来弄了多少个？这个呢，其实是一个非常好的积累工作，但还不够。为啥呢？我们感觉从数据库的角度来说，可能至少应该到大概1000到1500个左右，才能够基本上覆盖。为什么这么说呢？是因为我们跟做国际投资仲裁做得多的国际律所交流过，他们并不是自己去积累它他们是买一个数据库这个境外的国际投资仲裁的数据库还特别贵，1年要5-6万美元。所以说呢，你说叫我们在没有案子的时候专门去买个5-6万美元的一个数据库，第2年还得再续这个压力也蛮大的所以说呢，有些可能国内有些高校有但我相信咱们律所还不会花钱去买。在这个数据库中，大概就是说有将近1500到2000个的案例是进入了数据库。有了这样的一个基础，再通过关键词的搜索，包括以后有了 ChatGPT 做了插件也许就能够很快形成一个这个 submission 的 paper 了让大家再来 review 了。所以说这个想起来还是很令人激动人心的，但前提是什么呢？要有一个积累。第3个观察呢，就是要加强对国际投资仲裁程序的训练这个可能说到咱们的同学，这个在学校中如果有兴趣学这一个专业的话，尤其参加咱们的模拟仲裁赛，有得到了很大的一个锻炼唯一可能缺了2块也是实践中以后一定会遇到的，在国际投资仲裁中以及国际商事仲裁中都会遇到。第一，证据开示证据披露问题；第二，事实证人和专家证人的盘问问题。这2点其实是中国律师咱们是因为大陆法系的这种审判模式，再加上非英语作为母语，其实在这一方面呢是相对薄弱的。要怎么样有意识地对这块进行训练，至少让大家在学校学习阶段能够接触到它不知道这个猪怎么长成的，至少看到猪怎么跑。以后咱们有机会做到这块行业了的时候，再来把它慢慢的培养起来。这一点呢，可能也是从学术教育的角度需要考虑的一点。那很简短的一个前景的一个展望，我们讨论任何问题都是叫做立足于现时现地我们今天讨论的是咱们中国律师在目前这个时间点，也许在未来展望5到10年我们是应该什么样来看待国际投资仲裁这个事儿我觉得呢8个字：立足事件，放眼世界，立足现在。放眼世界是指国际投资仲裁是一个基于国际公法为基础的一个仲裁活动，这必然要求我们应该站得高看得远，放眼整个世界，在这个世界潮流中，这个国际投资仲裁的趋势进行研究和把握。但是站得再高看得再远，最后要怎么落地，是要落在我们现在的这块土地上。也许再过1代2代的培育有咱们在中国的律所也能够接到跟中国完全没有任何关系的投资人和东道国的一个投资仲裁案例，要来委托中国的律所做。我们相信在1代2代之后也许能看到，但可能短期5到10年内还不会这么快出现。我们所关注的还是如何服务中国的客户，既包括中国的政府，如果被诉的话，也包括中国的投资者，如果在走出去的过程中需要起诉东道国，万一作为一个最后的风险防范手段。客户对律师的希望一般是2点：第一，希望有结果确定性；第二，希望有费用确定性。结果确定性呢，这个要取是个水平问题这个尤其在投资仲裁，我们刚才谈到，它的学术性很强，有大量的文献可以研究。你选择的仲裁员，其实他有很多判例，有很多观点，也是能看出来的。很大程度上，我们开玩笑说，实际上打的是明牌。所以说呢，加强对它的研究和预判，至少对于比 一般的咱们商事仲裁的案件比，有可能它的预判结果还是相对可以客观一些的。至于费用上的确定性呢，这个呢，咱们中国的律所嘛，毕竟在中国这儿，按照咱们这边的收费水平相对来说跟国际律所比，还是有一定的价格的优势。但是呢，不是意味着说价格优势就要等于水平低，这个绝对不行。我们是要在水平跟他们差不多，甚至在某些方面研究还更深的情况下，费用还是符合咱们国情的一个费用。那在这样的情况之下，才有机会在国际投资仲裁的市场上，面对着国际律所的竞争，能够争取到中国客户的一些委托。那反过来，我们也要增加利益攸关方如何对国际投资仲裁有更深的一个了解。我们老去说这个东西多好，这个机制多棒没用，它还
12分钟，
最后1分钟，它还需要有一点什么呢？其实应该是要说得更详细、更具体。这个机制好在哪儿，坏在哪儿，优点在哪儿，弊端在哪儿？咱们把这事儿都说白了、说透了。如果一个客户要花几百万，不管后面是人民币还是美元，来投入到一个司法程序中的话，一定要让他对于这个事儿的利弊有充分的一个衡量。所以说呢，这个很简短的上面的一些汇报也很高兴看到各位同学在这几天的精彩的表演，希望大家能够维持对国际投资法和国际投资仲裁的热情和兴趣，在不远的将来看到大家是对这个领域的研究者、使用者和实践者谢谢大家。
谢谢，非常感谢张欣博士，很直观的介绍因为我们的同学们参加了这1周的比赛，相信一定是在学校学习了很多国际投资仲裁相关的知识。那么这些比赛呢，也给了大家一种模拟仲裁庭审的一个很直观的感受。当然，就如同张欣博士刚才所说的，就是缺少一个证据开示和证人盘问。那么证人盘问实际上在这个实际的庭审当中，可能证人盘问暂时的会很久，可能会做很久，有的可能做1个月都有可能的，所以它其实是一个非常非常重要的一个环节。那么大家学习了这么多，将来走上社会之后，你从事了这个专业之后，你会遇到什么？那有些时候，其实在学校里你是想象不到的。那有张欣博士这样的能够给大家做这么直观的介绍的这种机会，其实也非常难得。我们要感谢张欣博士。那么第二个我想说的呢，就是张欣博士其实提到了国内法律行业的一个非常现实的东西，就是这个收费问题，对吧？因为我们经常跟境外的律师合作，那么他们呢有一些法律他就是很坚持的，我就是计时收费，我没有别的收费方式。但是在国内呢，它的这个收费方式就会非常的灵活，尤其国内的企业呢，他还喜欢去跟你去讨论这个预算问题。那么如果是做一个国内的争议解决诉讼仲裁的案件，和做一个国际投资仲裁的案件，你的投入是截然不同的。国际投资仲裁案件投入的太多了，它的战线很长，像张欣博士说的，他要做很多很多的学术研究。那么这个时候呢，如果你要在这个领域去坚持，那么我觉得还是要有情怀，还是要有热爱，还是要对这个国家、对这些中国的这些企业，咱们要有责任感，要有使命感。大家才能够坚持得下去，所以我觉得这个是非常好的一个，张欣博士就是给我们立了一个非常好的榜样，谢谢。好，那么有请我们最后一位发言的嘉宾马志华律师，马律师呢已经在线上等待了很久了，马律师。那我们要不聊一聊？好。好的。
对，刚才张律师说的有一点，就是研究仲裁员。这个实际上是所有办理仲裁业务的律师第一要 就是你要知道你面对的是怎样一个仲裁庭，他的背景持什么样的观点，熟悉怎样的程序制度，你就很大可能的来判断接。
是非常活跃的一个国际仲裁员。我4月A、B。我去 ICC 实习回到伦敦已经是11月份了，10月份了。然后他说这个裁决出来了，这个已经完全公布了，是2006年10月2号，大家可以看 ICC 的那个网站。那么这个刚才就像，比如说张律师和这个韩律师说的，就是他从整个流程上来看呢，应该说跟国际商事仲裁的整体的操作是非常类似的，因为仍然是一个我个人观点啊，就是以一个普通法系的对抗制 adversarial system 向下的这种模式下的，而且呢大量采用了这种证人证言的这种证据形式的一个所谓的国际主流国际仲裁的这么一个程序，那它就会和这个大陆法系审理其他的一些案件的程序会有非常大的区别，更类似于普通法系的一个诉讼。而且这个就前一阵在那个普吉岛开一个研讨会，很多其实因为咱们是一大陆法的法系的传统的国家，跟很多大陆法系同行一聊，瑞士的、德国的、法国的，包括一些东南亚的一些韩国的这些大陆法系国家、日本的，其实对这个国际仲裁现在所谓主流的标准做法，包括大量的 document production 啊、disclosure 啊，像这种 cross examination 作为 hearing 的主要的内容，因为你有好多的 oral evidence。你是不是一定要引入这个 witness statement？ 其实对这是很有微词的，当然现在短时间内不一定能改太多。但是这个案子呢特别好玩的就是说，我在这个案子里学了很多东西。首先呢，就是说他除了 Neil Kaplan 当 chair 以外，剩下那两边的这2位仲裁员，也是国际仲裁界的大腕儿。一位呢申请人就是投资人 investor 指定的，叫 Charles Brower， 大家可以去查，老头儿也80了，是一美国人，原来最早是在那个。他其实成名是在伊朗和美国那个索赔的法院那个 tribunal， 他是一个那个法院的法官，他判了好多伊朗伊斯兰革命以后，然后伊朗原来的人和包括美籍的一些人，在这个 tribunal 的管辖范围内提起的一些索赔的一些诉讼，他判了好多 leading case。然后呢，他是一位，然后对面那位呢，就是匈牙利政府指定的呢，叫。Albert Jan van den Berg， 大家可能也听说过，他是一个荷兰人，老头儿也应该。就指定他，政府机构要指定他，因为知道他比较倾向 pro government， 所以这个也挺有意思。但是这2位呢和 Neil Kaplan 当时他们就组成这个仲裁庭，双方代理律师呢，其实大家如果看 record 的话，我对这个印象非常深刻。申请人 包括这个我刚才说加拿大律所，包括他们的 expert， 包括他们的这个 James Crawford， 然后对面匈牙利政府呢，实际上一开始他们好像用了一家很大的所的一个 team， 但是后来可能太贵了，后来换了一个相对比较小的一个 legal team， 只有2个人，是我印象是2个德国律师，一男一女，也就30多岁，非常非常厉害。等于这个从整个律师团的这个力量上来看，你要从人数上来看呢，绝对是 investor 这 claimant 这边是占优势。但实际上呢，我觉得尽管后来这个匈牙利政府败诉，但我对那2个最后仲裁庭都说你们虽然只有2个人，但是你们扛住了一轮又一轮的这个 arguments， 然后你们做的这个也非常的专业，非常好。然后刚才咱们提到说，比如开庭证人，因为这个案子涉及到匈牙利政府的，当时他这个 decree 是一个政府的一个法令的颁布。我印象特别深的就是当时出庭的有一位被申请人的证人，也就是匈牙利政府的证人，是当时匈牙利执政党的2把手。他呢被传唤过去以后呢，他要作证，证明他们整个这个 policy 如何制定，在整个这个 decree 出台的前前后后的一些问题。然后是皮埃的标文律直接来 cross 他，而且那个策略非常的成功，就是因为他的这个位高权重的这么一个人，你想国内执政党2把手能够被叫过去，搁在坐在一把椅子上被人盘问，很难受的一件事。而且皮埃标文律成功的把他给激怒了，当然这是一些技巧性的东西啊，技巧性的这些东西，就把他这个激怒以后呢，他说了一些我估计就是完全超出了他的 preparation 以外，而且对被申请人非常不利的一些话，实际上对整个这个案件的走向，我觉得还是有一定影响的。虽然说这种证人证言在绝大部分商事仲裁里边，你问所有这些国际仲裁员，你说在多大程度上你是根据一个 witness 的 testimony 来裁这个案子，很少很少，甚至很多人都说这完全浪费时间，我根本不想听那么多天。Anyway， 但是这个案子我觉得还是至少在那一场的 cross examination 里边，我觉得还是非常非常的棒。所以后来我跟那个皮埃标文律还说呢，我说 You are the lawyer I want to be， 然后他说 Arthur you made my day。印象非常的清楚，所以在这个案子另外的一个，我想跟大家分享就是呢，整个这个裁决书大家其实从 exit 可以看，都因为它全文本都是公开的嘛。我当时作为 legal assistant， 虽然不是 tribunal secretary 啊，那个时候还没有说正式的说委任我当 tribunal secretary， 但是我作为 Neil Kaplan 的助理，因为他要负责写这个裁决，而且后来 deliberation 就是合议的这个过程跟国内差别也非常大，他真是要安排一个 trip。所以当时住在英国的农村，那个 Charles Brower 跟 Albert Young Winterberg 他们就住在一个村里的一个小酒店，我就是每天负责早上起来开破车，把这2老拿车给拉上，拉到 Neil Kaplan 办公室，他们仨就一直讨论，边吃饭，然后拉回去，晚上然后这个第2天再接着来，他们可能讨论得有将近4、5天的时间，就是关于很多的一些艺术还是有争议的，还是尤其是关于 quantum， 关于这个赔偿金额的制定。是不是用之前的一个标准，还是用一个新的标准？其实3位仲裁员的观点并不是非常一致的，尽管后来还是一个 unanimous 的一个 word。所以我当时等于这一个裁决里边呢，前面的所有的什么 parties procedural history， contentions of the parties， 像这些东西呢，当然是都是我得写，咔写。写完了以后呢，就是这儿透露一个小的一个卖点，就是其中第423段，其中有一段是这么写的。While a sovereign state possesses the inherent right to regulate its domestic affairs, the exercise of such right is not unlimited and must have its boundaries. As rightly pointed out by the claimants, the rule of law, which includes treaty obligations, provides such boundaries. It is one thing to say that an investor shall conduct its business in compliance with the host state's domestic laws and regulations. It is quite another to imply that the investor must also be ready to accept whatever the host state decides to do to it. 这段话在这个裁决里边还被很多的文章所报道，因为它区分了一个政府管理行为和它的这个违反条约行为的这种非法的行为。其实这段是我写的，就是因为我当时写了个 note， 因为 Neil 他肯定是不让我写这块东西，但是我在看到这个问题的时候，当时写了一段，他说哎这段写的还行，后来我发现这段还真是被用上了。但是呢，就说回来，就是这个呢，可能是当时直接参与这个案子里边，能够真是全程的看到整个案子怎么去 develop， 怎么去打，而且双方的律师呢都展现了很高的水平。这个案子呢，也后来 成为了被后续的一些国际仲裁、投资仲裁庭 ICSID 的一些 tribunal 他们经常引用的一个案子。
好的，马律师，我们稍微打断一下，我们现在是12分钟了，我们是13分钟。
对，说就完了，没关系，
不好意思。
没关系，我话表密，没事说完了。
没有，其实你没关系。好的，谢谢马律师的这个精彩的分享啊，就是很直观的给我们讲了一个他参与的一个案件的整个的过程，那么这个也是非常的宝贵的，尤其是马律师提到了交叉盘问的过程当中，一个很重要的证人被激怒了，那这个呢就是非常形象了，非常形象的这样的一种。当然很多时候律师会采用一种策略啊，你把你激怒了，然后就让人觉得你是一个非常易怒的、非常不可信的这么一个人，那最后的结果当然也是可想而知了。那么另外呢，马律师还提到他们有一个 co-counsel 是一个教授，是一个学者，这个也呼应了。刚才张博士提到的那一点，就是这种学术性很强的案件，其实很适合是律师和高校研究机构共同去处理。好的，那我们谢谢马律师的分享，谢谢。那我们今天的因为时间关系，我们后面就没有问答环节了。我们今天。
好，我们祝贺以上获奖的选手。我们之后会给大家颁发的电子证书，希望大家也留意查收，谢谢。然后接下来呢，我们有请冒众香港仲裁中心副秘书长王浩成先生为我们宣布并颁发3等奖。
循环赛结果颁出来的时候，可能相信大家都是聪明的小机灵鬼哈，已经知道哪些队伍获得了3等奖。为了让它有仪式感，我再宣布一下，祝贺下列队伍获得3等奖，他们分别是上海对外经贸大学、宁波大学、苏州大学、华侨大学、郑州大学以及华东政法大学，祝贺。
请各位获奖的参赛队代表上台领奖，谢谢。好，我们掌声祝贺。好，我们来站中间合影留念。好，小心台阶，谢谢各位。好，接下来我们有请经贸律事务所韩正先生给我们颁发2等奖。
好的，我荣幸的宣布，获得2等奖的是西南政法大学、北京外国语大学、外交学院、天津财经大学。
好，有请上述参赛队代表上台领奖。 因为有些同学没有来。好，掌声祝贺。好，谢谢。好，下面我们有请北京市环中律师事务所邢源律师为我们颁发1等奖。
我很高兴宣布1等奖，获得1等奖的是山东大学、中山大学、中国政法大学，恭喜大家！
祝贺各位！我们一起靠拢一点。好，祝贺1等奖的获奖队伍。下面我们有请茂众上海分会秘书长加尔尼女士为我们宣布和颁发半决赛阶段最佳辩手的奖项，谢谢。
我非常荣幸地向大家宣布，获得第15届法兰克福国际投资模拟仲裁厅茂众中国内地赛区预选赛半决赛最佳辩手的2位同学是清华大学陈一文同学。接下来这位同学，我的名字我不一定能念对因为我拿到的是拼音，我试一下复旦大学于云可，欢迎，祝贺2位同学。
2位也是决赛的 opponents。掌声祝贺！好，我们一起拍照。好，祝贺2位。好，下面我们有请复旦大学法学院院长王志强。
模拟仲裁特别是四川大学、上海交通大学，祝贺他们。
好，掌声祝贺！再次祝贺2位获得季军的代表队，
恭喜你！第一个是代表颁奖嘉宾，恭喜你；第二个是要感谢你，作为复旦大学的校友，我要感谢你为复旦的赢得比赛，谢谢。
好，祝贺！ 谢谢。好了，到最后一个奖项，也是大家比较期待以及等待了很久很久的一个奖项，就是我们的冠亚军。现在我们有请茂众副主任兼秘书长王成杰先生为我们宣布和颁发冠军和亚军。
这个大家等了很久，也是这个5天的赛事最激动人心的时刻就要到来，也应该说今天晚上的高潮也要到来。那么我非常荣幸的宣布第15届法兰克福国际投资模拟仲裁庭茂众中国内地赛区选赛的冠亚军。亚军的获得者是清华大学代表队，冠军获得者复旦大学代表队。让我们以热烈的掌声为两支代表队表示祝贺。
好，请两个队伍的代表上台领奖。好，再一次祝贺两个学校。好，谢谢。好的，那今天晚上的一个颁奖仪式就已经全部结束了我们非常感谢各位领导、各位嘉宾，还有各位同学，还有各位现场的观众以及线上的观众对我们比赛的支持和关注。我们明年再见，谢谢大家。